having heard her voice on the voicemail message. I wouldn't count on it, unfortunately, but we will proceed, and she will have the benefit of being able to see everything that was said and shown to us, which will all be part of the record. And again, we hope we'll see her this afternoon and tomorrow, but that remains to be seen. I would like to welcome everyone to our second Washington, D.C. hearing on the Section 1201 rulemaking. I'm David Carson, the Copyright Office General Counsel. To my left is Rob Kasanik, Assistant General Counsel. To his left is Ben Golant, Assistant General Counsel. And to my right is Chris Weston, an Attorney Advisor in the Office of the General Counsel. Last Friday, we held hearings in Palo Alto, California, that addressed some of the proposed exemptions to this rulemaking. Yesterday, we began our hearings here in Washington. Today, we'll continue to examine proposed exemptions to the prohibition on circumvention found in Section 1201. This hearing is part of the ongoing triennial rulemaking process mandated by Congress in the Digital Millennium Copyright Act. Section 1201A1 provides that the Librarian of Congress may exempt certain classes of works from the prohibition against circumvention of technological measures that control access to copyrighted works. Any exemptions last for 3-year periods beginning on October 28, 2009, when the current exemptions expire. The purpose of this rulemaking proceeding is to determine whether there are particular classes of works as to which users are or are likely to be adversely affected in their ability to make non-infringing uses of works if they are prohibited from circumventing the technological measures that control access to those works. This rulemaking establishes a record on which the Register's recommendation to the Librarian of Congress is based. After our initial notice of inquiry in this rulemaking, published in the Federal Register on October 6th last year, we received 20 comments proposing exemptions to the prohibition on circumvention and 56 responses to those proposed exemptions. They're all available for viewing on our website. In addition to this hearing today, we'll be conducting hearings tomorrow in this same room. The agendas for all the hearings are available on our website, and there are some hard copies of the agenda out in the entrance to this room. We intend to post the transcripts of all the hearings on our website in a few weeks as soon as they're available to us. The comments, the responsive comments, the hearing testimony will all form the basis of evidence in this rulemaking, which, after consulting with the Assistant Secretary for Communications and Information from the Department of Commerce, will result in the Register's recommendation to the Librarian of Congress, and the Librarian is to make his determination by October 28th on whether exemptions to the prohibition on circumvention should be instituted during the ensuing 3-year period, and if exemptions should issue, to determine what particular classes of works should be exempted from the prohibition on circumvention. The format of this hearing will be divided into 2 parts. First, the witnesses will present their testimony. This is your chance to make your case to us in person, explaining the facts, the technology, hopefully showing us, to the extent that you can, what the problem is or isn't, and making legal and policy arguments that support your claim that there should or should not be a particular exemption. The statements of the witnesses will be followed by questions from members of our panel up here. The panel may be asking some tough questions of the participants in an effort to define and refine the issues and the evidence presented by both sides. Anyone who draws any conclusions from the fact that a particular question was asked is on dangerous turf, I would suggest. We try sometimes to be provocative just to get your best answers and to test the issues. This is an ongoing proceeding. No decisions whatsoever have been made thus far as to any critical issues in this rulemaking. And in an effort to fully obtain relevant evidence, we reserve the right to ask questions in writing to any of the participants in these proceedings after the close of the hearings. It's something that those of you who have participated in the past know is something we freely avail ourselves, a privilege that we freely avail ourselves of. I've introduced the panel, so just a couple of preliminary notes. As we've learned yesterday, cell phones and BlackBerries interfere with our audio signal. So please do what I did just before I started talking and turn off your BlackBerry or PDA or cell phone while you're in this room. Any of the witnesses who have not given us an electronic copy of the material they are displaying or performing or distributing, please do so. It's important that we have that so that we can review it later, and we want to make this available also as part of our record on our website so the public in general can see what it is that we're looking at ourselves. So with that, let's move on to the testimony. This morning, we're looking at two proposed classes. The first is audiovisual works released on DVD where circumvention is undertaken solely for purposes of extracting clips for inclusion in non-commercial videos.
That's actually the second issue we're going to do.
Well, Rob just tells me we're doing it in the opposite order, but I'll finish reading it anyway. Of extracting clips for inclusion in non-commercial videos that do not infringe copyright. Before that, we will hear testimony about another proposal for motion pictures and other audiovisual works in the form of digital versatile discs, that's DVDs, that are not generally available commercially to the public in a DVD form, not protected by content scrambling system. When a documentary filmmaker who is a member of an organization of filmmakers or is enrolled in a film program or film production course at a post-secondary educational institution is accessing material for use in a specific documentary film for which substantial production has commenced, where the material is in the public domain or will be used in compliance with the doctrine of fair use as defined by federal case law and under 17 U.S.C. Section 107. We have a number of panelists. I will introduce them as they speak. And our first panelist, Mr. Morissette, Mr. Quinn, are you both testifying? Is that right? Yes. Okay, so the first will be Jim Morissette of Cartum Quinn Educational Films, followed by his colleague Gordon Quinn, also from Cartum Quinn Educational Films. Is it possible to reverse that order? Absolutely not.
It might be easier to understand.
Of course, of course.
Okay, so I should start?
Please.
Okay.
And
Thanks.
just speak into the microphone.
Oh, the microphone. Yeah. Okay. Yes, I should know this. I'm Gordon Quinn. Thanks for the opportunity to come and speak today. I've been making documentaries for over 40 years. Our organization, Cartum Quinn Educational Films, makes films that are broadcast nationally on PBS, on NBC, also on cable channels. Our best-known film is probably Hoop Dreams. We also did some recent work as a 7-hour series called The New Americans about immigration. A recent film of ours, Terra Incognita, about stem cell research, just received a Peabody Award. And we have a long history of, we've made over 40 major documentaries, won all kinds of awards, and see ourselves as being very important participants in the culture and of our democracy. We tell human stories about real people in the world and try to put them in a context, historical, economic, social, whatever is appropriate to the story we're telling. I'm here today speaking on behalf of all the commentators who jointly submitted the supplemental comments proposing the exemption for documentary filmmakers. The International Documentary Association, the University Film and Video Association, the National Alliance for Media, Arts, and Culture, the Independent Feature Project, and Film Independent. These are all organizations that serve the field of documentary filmmakers, and we happen to belong to all of them except Film Independent, which is based in LA. We are out of Chicago and have been there for 40 years. But most documentary filmmakers belong to one of these organizations at least. Some of the individual filmmakers, Robert Behar, producer of Made in LA, Kirby Deck, director of This Film Is Not Yet Rated, Arthur Dong, director of Hollywood Chinese, Jeffrey Levy-Hinte, producer of Roman Polanski, Wanted and Desired, David Novak, producer of Burning the Future, Coal in America, and Morgan Spurlock, director and star of Super Size Me. The DMCA prohibition on circumvention is burdensome, intimidating, and it's really impeding our use to make fair use and public domain claims and material in our film. The exemption we're looking for is for a limited period of time, and it's for documentary filmmakers who, we make the case, are relatively educated about what fair use is, and what it is not. It's a narrow exemption, and we're only seeking the bare minimum we need to exercise our fair use rights. It's only for CSS, only for the next 3 years. CSS is the very minimum that we need. It's an important and very narrow class, and we are looking to restore the same fair use rights we have relied on for decades. It's such a narrow class that the benefit of the exemption will vastly outweigh any potential harm to the rights holders. I'm here today with Jim Morissette, the technical director of Cartemquin, who will speak about why various alternative circumventions are not really feasible or are extremely burdensome and really don't provide us with the quality that we need. Jim is, we're a documentary center, and so we work with a group of producers, and so we have a core staff of 6 people. Having a Jim Morissette with our organization is not the case that most documentary filmmakers face. Jim has an engineering background. He's a very high-level technician. Many of the things that I'll be talking about or he will be showing you are things that many of the most important documentary filmmakers in the country are working in very small production companies, and they don't even have access to some of the methods that people are proposing, saying, well, you can do this to get around it, you can do that to get around it. It doesn't work that well, and Jim's going to explain why. But in many cases, it causes us a great deal of grief. My colleagues, it causes even a lot more grief, because Jim is able to come to me and say, this is why the broadcasters sent it back, here's how we fix it, this is what we're going to do. They have to go seek and pay somebody to help them get through that piece of the process. Fair use is a critical component of what we do. This is undisputed in the reply comments, so I'm not going to really I don't think I have to make the case for fair use. I think we all understand why that's an important part of a free and open society and a democratic society. Particularly in documentary filmmaking, it's a critical part of how we participate in the democratic process. Fair use in documentary filmmaking has a long history, and it's predictable. It's more predictable than many other types of fair use, where there may be a great deal of controversy, like in music and things, where people are saying, well, this isn't, where do you draw the line? The DMCA is really having a burdensome effect on our ability to make fair use. DVD is the default distribution format, at least at the present time, and we anticipate it being so for the next 2 or 3 years. To give you an example of how we use fair use to comment on, criticize, put something in film and television or something in the culture that we get off of these DVDs, let me give you an example from one of our films, Refrigerator Mothers. This is a film that was made about the mothers of autistic children from the 50s and 60s who were told by the professionals, by the doctors and the experts, that they caused their child's autism because they didn't love their child. They were cold like a refrigerator. And so it's their story. And as a part of telling that story, we show the hold that Freudian psychology had on the popular culture in the 50s and 60s. And we show that there was a culture of putting a lot of weight on mothers for failing about all kinds of things. And we turn to the popular culture to show this. We show examples from feature films, and these are the ones that we managed to put into our film that we got off of DVDs. We show it by showing magazine articles and things. We edit this all together to make this point that this is how this culture and this belief in this system in the period that we're looking at played out as a consequence in these women's lives. It's a critical part of the film. It's also a very short part of the film. We understand fair use. We never take more than we need. And the amount of fair use material in Refrigerator Mothers is probably less than 5% of the total film, which is an hour-long film. It aired nationally on PBS. I think I tell that. We, of course, are concerned about that part of the DMCA, which says that even if the use that you're putting the material to is legal, breaking the encryption is in of itself not. And that's why we need this exemption. It's extremely difficult to maintain the necessary technical quality for fair use in broadcast or theatrical distribution. Various alternatives are not viable. Tremendous burden in technical expertise, time, and expense involved, and Jim is really going to talk more about that. Our proposed exemption provides a solution for that. Comments made in opposition to the proposal exemption have suggested some solutions, some modifications. Instead of enabling fair use rights, these suggestions further burden it. First, licensing as an alternative. Well, fair use, the whole point of fair use is that you don't have to license it. It undermines the purpose of the fair use doctrine. I'm sure you're familiar with the study that the Center for Social Media conducted, Untold Stories, in 2005, exploring the licensing process as an implication. Licensing costs are often outrageously high, are only increasing. Broadcasters are demanding more and more digital distribution rights, but right holders are unwilling to license copies. And I'll just digress for a moment. I was on a panel several years ago, and I was sitting between someone from an archive that was licensing material, and I was, on the other hand, I had the broadcaster. And you have the broadcaster laying out the rights that they expect to get, all of these rights for digital, other medium, pretty much everything in the universe. And I have the archive person on the other side of me saying, well, if that's the license that you want, here's what the costs are going to be. They're going to be incredibly exorbitant. We don't even know what this stuff is worth, and so you can't even half the stuff you're asking for, you're not going to be able to license. I'm sitting in the middle, and I said, look, guys, you've got to get together on this because I can't make a film if that's the case. So it's a little bit of a digression because that's what happens in the licensing world, and that stuff is still not resolved. That's still being battled out. But fair use is not licensing. Rights holders, I can give you an example of a situation where we did not use something that would have been fair use. This was quite a few years ago. This was in 2004. We released a major public television series, The New Americans on Immigration. And there's a Nigerian character, and he talks about the film Coming to America. And he says, we love that movie in Africa. That is our favorite film because it shows the incredible depth of Americans' ignorance about Africa and Africans. And he says, we use that line, it's in the film, and we just wanted to show a little clip from the film. We're going to show 10 seconds, just something where you'd see it, it's Eddie Murphy, that kind of thing. This was in the period that Untold Stories about how we had really lost the ability to make fair use because of all these threatening letters that had gone to broadcasters. Broadcasters weren't accepting it. It was a very dark time for fair use. And we tried to license it, even though I felt it was clearly a fair use claim, and we were not able to get the license. We were very persistent. We went up the line and just kept, absolutely not, they weren't going to give it to us in any way, shape, or form, and so we didn't use it. And the film was weaker because of it. In fact, standard provisions in studio licensing contracts prohibit criticism of the studio, the industry, the executives, the characters or the film. And let me show you. Maybe we just look at this slide for a second. Here is something from an actual licensing contract. It's something that I probably have signed, but I probably shouldn't have in the past over the years. Licensee represents, warrants, and agrees that the production in which the clip is used shall not be derogatory or critical of the entertainment industry or licensor or of any officer, director, agent, employee, affiliate, parent, or subsidiary of a licensor or any motion picture preceded or distributed by the licensor or any characters owned or controlled by the licensor, and will not be used in a manner or derogatory or critical of the motion picture. Anyway, you get the idea. I mean, you know, this is kind of off the chart, particularly if you're talking about fair use, because the heart of fair use is that we have to be able to criticize, to comment on, to put things in context. And so licensing is simply not a solution to the problem documentary producers are facing with fair use, which is not to say that we don't license things all the time, because our view of fair use is very prescribed and very narrow, and when it's not fair use, our broadcasters expect, and we as professionals believe, that of course we're going to license it. We only use fair use when it's appropriate. Fair use is in the copyright law because you cannot use ownership to prevent free expression. So that's my feelings about going down that path. There is also a suggestion that documentary filmmakers be required to ask permission or make a good faith effort to obtain an unencrypted copy of the material from the copyright holders. This has some of the same problems. I don't know how this would play out, but the problem is that these are the very people that we've had all these problems with over all these years. It reads a permission requirement into fair use. And I mean, the lawyers are saying I kind of say this wrong, but I mean, I view fair use as a right. It's like it's something that we need as documentary filmmakers, as storytellers, within these very prescribed guidelines, to be able to participate in the culture of the community, to critique things in our society. It's something that I shouldn't have to ask permission for. It can lead us on, it could lead us on wild goose chases. If we feel it's fair use, we still sometimes do go to the artists, but we shouldn't be required to do so. I have many situations in which I've gone directly to an artist. We're using something in fair use. I want them to know it. We acknowledge it. We, of course, want to acknowledge that we're using something, and we put that on our films, but it shouldn't be a requirement, and it doesn't solve this problem with how do you get your hands on the material. There can also create requirements to pay lab fees, and again, this is where things can get a little bit strange. You can get into a situation where you have the DVD, you have the material, you know what it is, and yet when you go and say, okay, well, could we get this in this form, or could we get it unencrypted, all of a sudden somebody's telling you, oh, yes, but we're going to have to go back to the negative, we're going to have to redigitize it, it's going to be, cost a lot of money. The other thing is that in our work, and particularly in some other documentaries work, which is also very professional and I highly respect, there are a lot of clips used from a lot of different things. They're very short. So you're putting together a montage of a whole bunch of stuff, creating a new kind of thing to sort of show the culture of the times, or show how people have been treated in certain kinds of media and that kind of thing. And so you're using lots and lots of different pieces. If each one has to go through a laboratory process and stuff, it's going to add up to a lot of money. There was one other suggestion to modify the proposed class by adding the word solely to the class that would be restricted to accessing material solely for use in the specific documentary film. We don't object to this change. The Copyright Office thinks it's best to adopt the modification for clarity. We would agree. The modification is consistent with our goal to alleviate the detrimental effect that the DMCA is having on documentary filmmakers' inability to make fair use. And yes, we only want to use it in the documentary that we're making. We don't have all these other things in mind or some kind of slippery slope. So that's not a problem for us. we don't see any real harm to copyright holders, and that's important to us because we are copyright holders. We have 40 years of material that we own the copyright to. We distribute and sell our DVDs. Some have CSS encryption, which is put on by our subcontractors. We understand concerns about copyright infringement in the digital age. We think there is really little threat to the value of CSS because our proposed exemption is narrow. It applies only to fair use and to use of public domain works. The uses are well established and permitted. It does not apply and cannot be used for infringement by consumers watching a movie in their basement or, that kind of thing. So for just watching something they didn't buy. It would apply only to established documentary filmmakers community. The potential risk that some filmmaker would circumvent CSS based on their own erroneous determination of fair use is small and growing smaller. The only potential risk presented by this is the only potential risk presented by the exception, and it applies to the established documentary filmmaking community, which is professional, thoughtful, and responsible about fair use. That's why we came together to come up with the Documentary Filmmaker Statement of Best Practices in Fair Use with guidelines and drafting help from the Center for Social Media and the Washington College of Law at American University and legal scholars from across the country. So we put a lot of effort into kind of looking at the law, say, what does the law mean for us? And now we take this best practice thing and we speak with it all over the country. Just this year, just since the new year began, I've made 6 presentations on this to different groups of filmmakers who are also taking it to lawyers and to universities where people are teaching films, because there was a lot of misconception about what fair use is and what fair use isn't. And we want people to have a sense of how it is, the sort of confines within which it should be used. This statement outlines what we consider to be responsible fair use practices. The other thing that has happened is, and I couldn't say this a few years ago, but because of the publication of the statement, because of the work that we have done, now the broadcasters are accepting our fair use claims, and we are able to get E&O insurance, which is extremely important because the broadcasters demand it. And we getting E&O insurance for our fair use claims, and we have to get that insurance. We have to go to an IP lawyer and get a letter. They review our fair use claims. We send them all the clips. We send them, the log. They look at it, and they give us a letter putting in kind of legal language for the insurance companies why this is a legitimate claim. Copyright holders still retain their full rights and remedies for copyright infringement, but without the exemption, documentary filmmakers will continue to bear the unreasonable burden in making fair use in public domain. This burden is real and substantial. I certainly, if someone was stealing our work and infringing on our copyright, I would go after them, and I have other recourses for that, which I would use. It is my understanding that it is legal to access public domain materials on DVD if that is all that is on the DVD. But today, this is about the whole question of public domain, but today it is almost all public domain material on DVD is bundled with copyrighted material. A silent film in the public domain may be paired with a newer copyrighted soundtrack on the DVD, or another film in the public domain may be bundled with specific features such as mini documentaries or the making of film, that kind of thing. If it is clear whether it is legal to access it is far from clear whether it's legal to access the public domain material in these cases. The reply comments seem to ignore this. Public domain works are critical for many important historical documentaries. Without the exemption, some other guidance from the Copyright Office, we are unable to access increasingly large amounts of public domain materials. So, in conclusion, I would just say that I think this is really, it's an important issue to us. We're not asking for any kind of broad and vague and unfocused exemption. We just want it It, very much like fair use itself, the part of the fair use law that one of the lawyers read to me, because there's all this question about how much can you use. People talk about the 30-second rule. And he read me the part of the law that kind of says you can use as much as you need and no more. And I think that's all we're asking for here. We're not asking for more than we need. We're just asking for the minimum that we need and no more. And we're not trying to open up some barn door to people random piracy or anything like that. And because we are a very defined class of people who have put, as a group of people, spent a lot of time and effort in the last 5 years or so getting educated about what fair use is, I think it's a fairly legitimate claim. So that's my testimony. Thank you.
Thank you. Jim Morissette.
Okay. Change the technology here. Good morning. My name is Jim Morissette. Good morning. Jim Morissette. I'm the technical director of Kartemquin Films. I've been working for Kartemquin for the last 30 years. Gordon and I have worked on many, many productions, and almost all of them have come to me to be fixed at some point or another. I'd like to talk to you today and sort of explain how we deal with the analog alternatives to CSS encryption and the problems that arise from that, specifically problems that affect our ability to get our shows on public television. It's been suggested that documentary filmmakers like us could use VHS tapes because they do not have CSS encryption, and we indeed have used VHS tapes. And I think, though, that it's pretty universally accepted that VHS image quality, even on a brand new VHS tape, is vastly inferior to DVD to begin with. But the problem doesn't stop there. The problem that we're coming up against right now is availability. It was mentioned by several people yesterday that VHS tapes from distributors are no longer being made. In fact, they stopped. The last distributor ended it last year in 2008 in October. So newer material, television shows and new movies that have come out, are not even available on VHS. But some of the older ones possibly still are. And for our movie on stem cell research, which was broadcast in January of this year, we wanted to include a fair use clip from the Woody Allen movie Sleeper. And we said, well, we can't break the encryption, so let's see if we can find a VHS copy. We couldn't find a VHS copy. We sent interns out to all the local small libraries in the Chicago area, and they finally found a copy at a suburban library that had not thrown out their VHS tapes yet. And so we used that tape as our source for that clip. And this is what we had to do to get it into our program. Push the forward key? Yeah. Forward arrow.
Okay.
These are the steps necessary to get a VHS tape into a program acceptable for broadcast television. You play the VHS tape on a VCR. You have to run it through a time-based corrector in order to remove the analog Macrovision copy control, and then it must be recorded onto a digital form, a digital tape, which is then transferred into the computer and created a file for editing purposes. And as you can see from the chart, especially the red boxes indicate problem areas. Problems with the source material, with the Macrovision. Problems running through the time-based corrector, because the time-based corrector essentially has to convert that analog signal into a digital signal and then back to an analog signal after the Macrovision is removed. The signal is then recorded on a digital VCR, which again turns analog into digital before we have a tape that we can use. And in all of these steps, we have issues with the brightness, the black level, and most importantly on VHS, there's something called head switch, which is a couple of lines of noise at the bottom of every single VHS tape. It's part of the format. And consumers don't usually see it because their televisions don't show the very last line or two. But broadcasters see it. And that's an important distinction that I will make throughout my presentation, is that there's sort of two kinds of quality. There's the image quality. Is it in focus? Is the black and white contrast viewable? But there's also all these additional hidden signals, the sync signal, the blanking signal, the color burst signal, all of these things which broadcasters insist must be within a very narrow spec. In fact, the FCC insists that they be within a very narrow spec. And if we send one of our programs to public television for broadcast and any of these clips are not within spec, the problem comes back to us to fix, and it is not easy. So what do? Well, let's explore a couple of other alternatives to VHS. One alternative that was mentioned and actually presented yesterday is an alternative called scan conversion. Next slide, please. Scan conversion, really, there's three ways to do it, and the way that was shown yesterday is by using a camcorder. This is the exact same setup that was used in the 1950s called kinescope in order to record live television before videotape was invented. Basically aiming a camera at a TV screen that's playing whatever material you want to play. However, the steps necessary here raise even more issues that have to be dealt with, both in the transfer, in the setup, and in the post-production part of it. Shooting a TV with a camcorder, as you saw in the clip yesterday, for those of you who were here, involves darkening a room, setting up the camera, dealing with audio connection issues, which are a problem with consumer camcorders because they're expecting a mic level signal as opposed to the line or higher level signal from the DVD player, which causes distortion. And the framing is critical. If you aim at a TV set and it's a little too wide a shot, you're going to get parts of the TV set in the picture. If you zoom in to avoid that, you start cropping off part of the image of your source material, and you start degrading the picture as you magnify it. But there were more serious confusion and technical issues that I saw in the demonstration yesterday. In the demonstration yesterday, a high-definition camera was used to shoot a TV screen. All high-definition cameras are widescreen, 16 by 9, unlike the square 4 by 3 standard def image. If that camcorder had been a standard definition camcorder, it might have only been capable of shooting a square screen. Well, what do you do if you have a wide source picture and a square screen? You end up having black bars on the top and bottom, which, of course, degrades the image even further because only about 40% of the picture is turned over to black bars. What concerned me about the demonstration yesterday was that the source material chosen was a very dark, fast-moving, quick-cutting Harry Potter clip. And it was impossible for me to tell whether or not the frame image off the camcorder was jerky, whether it was flickering, whether the colors were true. If they had chosen something more normal that we would use, for example, presidential speech or something that was on DVD where we could actually see a human face and judge the color, it would have been more easy to compare. But most seriously yesterday was the fact that we did not get the camcorder footage compared directly to a DVD. I'm not sure why they couldn't have just put the DVD in and shown it to us. What they used instead was a downloaded, QuickTime, compressed file, which of course didn't look any better than shooting off the screen. And I'm not convinced at all that any of that material would pass the public television standards. So I was very disappointed. The other thing that they failed to mention is that once it's on the camcorder, you're not done. You still have to download that footage into a computer. And if it's high definition and you're making a DVD for presentation or inclusion in a standard def program, you have to down-convert that high definition. That's another step before it's able to be used appropriately. So, I'm still not convinced that this is at all an alternative to our problem here. Another method, which is a little more sophisticated in this day and age, is to not use a camera at all, but to use a black box, a piece of hardware that actually records whatever is on a computer screen. And these kind of literally called scan conversion boxes, are often used for people that are making training videos that want to show the cursor and the movement of how computer software works. But it can be used to capture images off the screen. So you play your DVD on the computer, capture it with this hardware box, and so hopefully output a video signal that you can then record. The problem is computers don't play video the same way that television plays video. Computers play video in a progressive mode. But public television and all the broadcasters want a final product that's an interlaced mode, which is what's coming out of the DVD if you play it on a DVD player. So there's this change from progressive to interlace and back to progressive, which leads to a vast amount of image loss in terms of image resolution, which is literally cut in half. There's also a synchronous problem with the audio because there's a significant delay coming out of this scan converter box. It can be as much as half a second. And the audio does not go through this box, only the picture. So you end up with an out-of-sync product that you then have to resync in the editing room. It's doable, but it takes time and effort. A third method, Gordon, please, thank you, of scan conversion is using actual software. No black box required. Just go out and buy a $100 piece of software, and it will record anything that happens on your computer screen. Well, I've tested some of these. Some that have been mentioned yesterday were Snagit, and we've tried Jing Pro and several others. And while they may be acceptable for producing web clips, low-resolution web clips, they don't do a very good job. In fact, they do an unacceptable job for our use. Why? Because they don't have the ability to capture the full frame rate of the DVD playback. DVDs play back at 30 frames a second. And these software programs, even on a quad-core Intel Mac, are lucky if they reach 15 frames per second. So when you play them back, you get jerky motion. And the other problem is it's very difficult with these software programs to define a precise part of the picture to record. You obviously don't want to record the player window and the toolbar at the top and the cursor. You want to just record where the movie is playing. And if you get it wrong, your file has to be blown up or cropped or something, manipulated, in order to get the proper frame size for the program that you're editing. There's only 3 frame sizes allowed for broadcast, and if you're off, you're in trouble. If the picture's too small, you have black lines around it, that's not acceptable. If you zoom in on the picture to cover up all the black lines, you lose image area, and you also degrade, again, the visual quality of the image. So this is no good either. So what do we do now? Well, let's go to the next step, and this is the step that we have used, that we are using up to this point, which is called the DVD analog transfer method, often nicknamed the analog hole. And this process is very similar to our VHS process that we used in the past, whereas we play a DVD, an encrypted DVD, on a standard DVD player. And again, the DVDs, I don't know if everybody knows this, but the DVD players also have a Macrovision analog copy control still, so that the analog output of the DVD player is not directly recordable to a VCR. You have to still run it through an expensive time-based corrector to strip that off. But then you simply record it on a digital VCR and use that as your new source for your program. The problem with this method is several-fold. One is you're starting with an analog signal out of the DVD player. And if anybody's ever connected a DVD player to their new plasma screen via analog composite signal and compared that with the digital signal, it's like night and day. The composite signal is blurry, the colors are washed out, it's just a mediocre signal. There's also an issue with black level, and the only reason I raise this is because it affects not only the look of the image but also whether or not public television will accept it. All analog signals have a black level that's higher than digital signals. And because of that, you have to modify the black level coming out of the DVD player And that can be done in various places, but you have to do it carefully so that you don't degrade the actual visual image quality any more than necessary. But I'm sure you've all seen on TV shows a lot. All of a sudden they'll cut to a shot and it looks all washed out. It's kind of gray instead of having richness to it. That's because it came from an analog source and it wasn't processed properly. So these are issues that affect our ability to use this material in a way without having to lose image quality and continue to do this high level of processing. What we do as a standard workflow is that even with all of my expertise and the equipment that we have at Cartemkin, we still have to send our programs out to a high-tech gatekeeper. And we send them to Pillar to Post, which is in Arlington, Virginia. And they are one of the approved public television quality control houses. And they run our show through their system, and they send us back a computer readout, which if it's 5 pages, we feel fortunate. Sometimes it's more. And say, this doesn't work, this doesn't work, this doesn't work. And this shot, you can't. You got to replace this shot. It's technically not the right signal. The frame is too small, too big, too much blanking, colors, whatever. And these are things that are grounds for rejection from broadcasts. And so either we try to fix them or we have Pillar to Post fix them in some cases, which we did with New Americans. And, of course, this adds an additional burden in time and money. I think it's a key point here, though, that it's not just that we need something that's, quote, good enough. If we were showing a clip in a classroom, some of these other methods possibly would be good enough, even though there's still a heck of a lot of trouble and time and effort. You're not going to have somebody in a classroom say, oh, well, the blanking was off or your black levels were wrong. But for broadcast, the buck stops there. And if we want to just be able to distribute our films on national television and broadcast, and it's not just the broadcasters. Many of the cable stations like Discovery and History Channel are equally picky about maintaining standards. And when these analog conversions come into the show, they stand out as being visually and aesthetically, where did that come from kind of thing, to being outright kicked out and have to be replaced by something that's technically better. A lot of filmmakers don't have the option to do this. They can't afford it. And so they just give up and don't use the material. If we get this exemption, we'll be able to extract digital files that are the right aspect ratio, the right frame size, the right frame rate, the right black level. Everything will be correct. And it's just a matter of cutting them into our show. I think it's critical to mention again, I was going to start with this, but I'm going to mention it again, that when we make fair use of a clip in our documentaries, we only need these short clips, less than a minute each. We never convert more than that. It's not like there's a copy, a de-encrypted copy of the movie sitting on a hard drive somewhere at Cartemkin that an intern could take home. We only capture the short clips that we need, and only those are ever converted to editable computer files for our show. So it's not like we're just ripping everything as it comes in the door thinking we might need it someday. It's a lot of work to copy these things over. And we only use the small clips that we feel are definitely fair use material. Thank you for your attention.
Thank you. I think that's it for the proponents of this particular exemption, correct? Then we're going to move to the other side and first go to Bruce Turnbull. Congratulations on moving up to the front row, Bruce.
Thank you. Well, as you know, but for the record, I am Bruce Turnbull of the law firm Weil, Gotshal & Manges, LLP. I'm pleased to be here today representing the DVD Copy Control Association. Again, we appreciate the opportunity to present our views on the issues this morning. I won't repeat my comments from yesterday, but would ask that you keep them in mind, particularly with regard to the standard for class of works. As I stated yesterday, but I really want to emphasize that again this morning, DVD CCA's primary concern is the viability of its technology. Well, obviously, our technology is used to protect the movies and the other audio-video material. In this context, we are the proprietor of the technology that's at issue here. CSS enabled the development of the DVD market and is still critical to its commercial viability. Section 1201 was enacted, in fact, with CSS as the example of a technological protection measure that was in use at the time. CSS was introduced in 1997 in the United States. The DMCA was enacted in 1998 with full knowledge and understanding that this was the premier technological protection measure that was available at the time. And so the provisions of 1201 actually were, the members of Congress understood how they would work in relation to CSS. And so we think it's very important that the protections of 1201 remain with regard to the viability of the technology. Now, specifically with regard to the documentary filmmaking comments, first of all, we see these as being in a different category because they are commercial in nature and not in relation to education, as we discussed at some length yesterday. The 2006 film professor's exemption was deemed by the Copyright Office and the librarian to be necessary for pedagogical purposes, and those were key to the decision at that time. Here, we simply don't have that same quality. We just went through. I won't try to match Mr. Morissette on the technology. I will note that he'll be happy to know that almost all DVDs that are being released today do not enable macrovision. So for the future, all of the circumvention of macrovision, I'm sure if they were here, they'd have something to say about all of that. But in any event, it won't be necessary. For most movies, not all, but most. The alternatives, understand the limitations of what was presented yesterday by MPAA representative with regard to the camcording. I think the point that was being made, and I think very well made by that, was that the camcorder option has become a viable one in light of the development of technology, both as to the nature of the screens that you're taking the picture of and the type of cameras that are being used. I guess I'm a little hard-pressed to think that the professional filmmakers would actually have the great difficulty that were suggested in terms of sizing the image with their cameras, but I think the image that was presented yesterday and the comparison that was made with what we had available from the film studies professor who said this is what they wanted to use in their class. And so the comparison, I think, was intended to be a comparison to say, is this good enough for the purpose that the film studies professors were putting forward for their use? And so I think not quite fair to criticize the comparison that was made. It was made for that purpose. I also think that it's important to emphasize that the documentary filmmakers, well, everybody has time constraints, but they do not have the same time constraints as the film and media studies professors had put forward in the last round and again yesterday. Part of the basis of the 2006 decision was that the film studies professors were limited to 50-minute class times and couldn't use some of the technologies because of that, and that they're making final revisions to lectures the very night before the lecture is actually delivered. In the filmmaking that we're talking about here, they're talking about a relatively lengthy process, and the filmmakers have time to take the steps to undertake some of the alternatives that the film studies professors felt were not viable given the time constraints. I will also say and reiterate specifically in this regard, In each of the rulemaking contexts, 2000, 2003, 2006, and again this time, DVD-CCA has said we welcome people to come talk to us about their specific needs and concerns. No one has ever done so. And I think that we would be far better off if the marketplace could work this out through specific arrangements that might be made with DVD-CCA as the proprietor of CSS, rather than having sort of public permission for circumventing the technological protection measure that was one of the things that Congress intended to present. I'll be happy to answer any questions, and I guess I'll save my remarks on the other exemption for when we get to that one.
Yes, please. Steve Metalis.
Thank you. It's good to be back here again this morning. For the record, this is Steve Metalis from Mitchell, Silverberg, and Knupp, representing 9 copyright owner and creator organizations in this proceeding. And I appreciate the chance to respond to the presentation regarding proposed exemption 11B. I think it's clear that the proponents of this exemption have made a good effort to try to bring their proposal within the existing framework that the Copyright Office has been using and that Congress set forth, and that stands in contrast to 11A, which I thought until we sat down this morning we would be talking about first. But I think they've definitely tried to avoid some of those flaws, but I think there are still some of the same problems that we also see with the other proposal. Let me start by talking about non-infringing use, then about alternatives, and then about narrowing any proposed exemption in this area. It's clear that what the office needs to be deciding here is whether the prohibition on circumvention of access controls substantially impedes a use that is in fact non-infringing. That's the standard that the office has used consistently throughout the proceeding, the history of the proceeding. Sometimes they say generally non-infringing. I think we've collected the citations in Section 2 of our submission, but it's got to be something that the use that is enabled has to be something that you could be quite confident that you can say is non-infringing. Now, is that the case with the use of clips in documentary films? Sometimes it is, sometimes it's not. And again, on page 68 of our submission, we do make reference to the Presley case, and it's not the only case, but there certainly are instances in which documentaries were made using clips that were found not to be fair use or were found to exceed the scope of fair use. Now, I'm not suggesting that anything that Cartemquin has done falls into that category, but the point is that the office is not in a position to, under the law, is not in a position to recommend an exemption unless it can determine that the use that's enabled by circumvention is in fact non-infringing. And I also think it's fair to say that this is inherently more difficult when the basis for the claim of non-infringement is fair use, Section 107, because that's inherently a case-by-case determination, as we all know. And it's a little different when you're relying on one of the other statutory exemptions or when permission is involved. But that kind of comes with the territory. I think that is a burden that the proponent has to meet. They attempt to meet that in this case by using a couple of proxies. It only applies to a documentary filmmaker who is a member of an organization of filmmakers or is enrolled in a film program or film production course at a post-secondary educational institution. And I think the intent is to up the chances, increase the chances that the resulting use is going to be a fair use under the law. And I think Mr. Quinn said the risk is small and getting smaller because of the activities of some of the organizations that he is involved with. Well, again, I think this is a good effort to try to come up with a proxy for getting to meeting the test of in fact non-infringing. I would have to question whether it succeeds and how much or how exactly being a member of a particular organization increases the likelihood that the use you would be making would be non-infringing. I think there's something of a disconnect there, and even documentary filmmakers have pointed this out. If you look at the reply comments of Vamp Production, they question why this should be, why there's necessarily any connection between the likelihood of non-infringement and membership in an organization. As far as enrolling in a film program or film production course, again, that is not clear to me what the connection is that would lower the risk that this would be non-infringing. We heard yesterday from Professor DeSherney that in many of the film programs that he's involved with, students apparently never touch a camera or do anything having to do with production. We don't know to what extent they're taught about fair use in those types of classes. So I would suggest that being enrolled in a film program or film production course at a post-secondary educational institution would have a very tenuous link, if any, with the likelihood that your use would be non-infringing. So this, I think, is the first big hurdle that this proposal attempts to surmount, but I would question whether it does so, and that's the question of whether the use will be in fact non-infringing. Now, then let's turn to the question of alternatives. And there has been a lot of good discussion about this already. There are really three that I'd like to talk just briefly about. One is licensing or non-objection, a consensual path. The second is the scan conversion that was talked about, camcording. And the third is the use of other digital formats. On the first point, I think it is important to clear up that there may be some confusion here between two concepts. One is fair use and the other is non-infringing use. They're not identical. One subsumes the other. Fair use does not require permission, but a use that is permitted is a non-infringing use. And if the office finds that people who wish to circumvent can make a non-infringing use by getting permission to make it, then the test of the statute is certainly satisfied. That's a non-infringing use. And I think Mr. Quinn really gave two reasons why he objected to this, and the second one really is that I shouldn't have to ask for permission in order to make fair use, and that's absolutely right. But you can certainly make fair use without obtaining these clips. And I guess this is the point at which, since Fritz Attaway is not here, I will refer to the decision of the Corley decision in the Second Circuit. Fair use has never been held to be a guarantee of access to copyrighted material in order to copy it by the fair user's preferred techniques or in the format of the original. And that conclusion, of course, has been echoed by the office in many of the prior proceedings. So you certainly don't need permission to make fair use, but you also don't need to circumvent in order to make fair use. There is information in the record about the licensing situation. I'd call your attention to the comments of Time Warner, and I believe it's 368 instances last year in which they granted permission or expressed non-objection to filmmakers involved in documentary projects. So the picture isn't certainly quite as bleak as it might be presented from the perspective of the proponents. And the discussion of lab fees, I mean, if lab fees is the cost that you incur to get a higher quality clip, it's hard to see that it constitutes an impediment flowing from the prohibition that is impeding non-infringing use, even assuming you can show non-infringing use. Lab fees are sometimes charged, certainly by the studios. I think that the Time Warner submission discusses that, but it doesn't seem to me that would constitute a basis for circumvention under the statute. Then on the scan conversion, and I think the charts that Mr. Morissette presented were very interesting and helpful, and we will take a look at those. The proponents saw fit not to present those in either of the two previous rounds, but to bring them to this hearing where we're seeing them for the first time today. But we'll be interested to take a look at that and have some of the technical experts, which I'm certainly not, give some reactions to that. And the only point I would make, I think Bruce has already talked about the camcording demonstration from yesterday, and I would encourage the office to compare apples with apples here. I guess when we got a disc from the Copyright Office, maybe it turned out to be a pomegranate, so we did the best we could. But I hope you could make that type of comparison with the material that you have in the record. The final point I'd like to make about alternatives is that I think the submissions overlook the fact that there are an increasing number of digital formats that aren't protected by access controls that are being used to distribute at least some of the material. I'm not saying all the material that the proponents are interested in excerpting. The submission says that the DVD format is becoming more and more dominant as the means for distributing digital audiovisual products. I would have agreed with that up until a year or two ago, but I think in the day and age of Hulu.com and all of the network sites that are providing a lot of video material in digital format, much of it in the clear, not all of it in the clear, I think there are increasingly there are going to be other digital formats that will be accessible without circumvention, and that hasn't been even mentioned by the proponents, and it certainly is part of the overall environment here. So let me turn, in conclusion, to some of the points about narrowing. If the office concludes that the proponents have demonstrated that their use will in fact be non-infringing, and if they have persuaded you that none of the alternative means that either they have talked about or that we talked about and they didn't talk about, such as other digital formats, if you're persuaded that none of those is sufficient, then I think we turn to phrasing of any exemption that would be recognized. And I had 8 or 9 points here, but there may be 1 or 2 of them that have already been dealt with. I mean, first of all, just in terms of the phrasing of the exemption, we don't think it's appropriate to refer to public domain material because no exemption is needed there. The precedent of this proceeding is clear on that. We also don't believe it's wise to make the reference to fair use or Section 107. And I think we'll be talking about this later this morning, but I think if that becomes an element of these exemptions, we're far down the road to saying whatever you do, so long as it results in a non-infringing use, is okay. And I think Congress made it clear that was not the law, and that's not within the purview of what they expected or would allow this proceeding to end up with. We do think it's important to stress that any exemption should be applied only when necessary, and we do think it would be a good idea in this context, if there is to be an exemption, to require some documentation of a good faith effort to obtain the material without circumvention. As we've said, there are many alternatives, and if in fact the office finds that it is persuaded that those taken together won't cover the field, then I'm not sure what the objection would be to requiring that good faith effort and documentation of that good faith effort. We also suggested that perhaps there should be some notice of use or some record developed about the circumstances in which there is circumvention here. And that would certainly be useful if an exemption is granted in terms of looking 3 years down the road as to how it was used. So we would encourage you to consider that. I think the Solely issue has already been addressed, and we appreciate the proponents' agreement on that. Solely for this purpose, I was a little puzzled to hear that circumvention could be accomplished in a way, at least I thought I heard, that circumvention could be accomplished in a way that only the clip of less than a minute would be in the clear. I'm not quite sure how that works, and I noticed that in one of the charts that was not shown here was how the circumvention exemption would operate, which boxes you would go through if you had the circumvention exemption, but perhaps that could be spelled out later. We certainly would suggest that the language that you have used in the ebook exemption be applied to any exemption in this field that requires that the conditions the applicability of the exemption on a showing that all the existing digital editions are protected by CSS. As we've said, there are increasingly digital formats that are available that aren't protected for much of this material. I certainly don't say for all of this material. And finally, two, which really are just drafting suggestions. One, I don't think it actually clearly states that this exemption is limited to DVDs protected by CSS. I think that's the intent of the proponents. And finally, any exemption should clearly spell out who it is that can exercise this exemption. So these are sort of the more general suggestions we have had for how the office should approach these exemptions that increasingly and to somewhat distressingly are defined in terms of the characteristics of the use and the user. I share the concern that Bruce Turnbull has stated for the record, and I'll state it for the record as well, as far as that trend in the in this proceeding. But I think some of the safeguards that we've talked about here that could be applicable to any exemption in this area would probably help in terms of minimizing the risks there. Thank you, and I'd be glad to answer any questions and either now or later.
Okay, Steve, I did want to ask about just because that wasn't clear. I wasn't clear what I was hearing, and that last in your list of your litany of kinds of conditions you'd like to put on it. What I wrote down was you said clarify who can exercise the exemption. Is that what you said, or if not, what did you say? And could you expand on what you meant by that?
Yes, the exemption is kind of drafted in a passive voice. It's motion pictures with certain characteristics when a documentary filmmaker is accessing material. So is the documentary filmmaker the person that can circumvent? That's really my question. Or is it the documentary filmmaker, his agents, who is it that can do this? So that's just to be clear.
So it sounds like a drafting issue, really.
I think so. I think those last two were pretty much drafting issues.
Okay. The plan was to go directly to the reigning witnesses on the next issue, but I think it might make sense to spend 10 or 15 minutes at least asking some questions while we've got these issues in our mind. I'm not saying we're going to ask all the questions we have on that because we need to make sure we get everyone in, but I do think it probably would be helpful for us to at least ask some questions that now that we have them, now that you're here. I don't know, do you want to start, Rob? Or? Okay, well, let's start with what Steve just was talking about, and these will be questions depending on the particular issue that I'll be asking to both of you, perhaps. I just want to sort of get primarily the reaction of the proponents of this exemption to some of those conditions that Steve was talking about. In some cases, I may want some reactions from Steve, too. Let's start with what I have down as the first thing you mentioned. There's no need to mention public domain material. There's no exemption needed there because Section 1201 doesn't cover public domain material. I actually think I heard you respond to that in your main case, but just in any event, I'd like to hear your position on that, and then Steve may have a response.
Yeah, I mean, I was a little confused by that, but the point that we're trying to make is that you have a DVD. It has stuff on it that's in the public domain, but it's bundled with, and the whole thing is encrypted with all kinds of other material. Mm-hmm. So to get to the thing that is public domain, you then have to break the encryption, and that's sort of becoming more and more common. I also just want to comment on this idea that there's all these new sources of things. And remember, we're talking about broadcast standard here. We're still talking about broadcast. So a lot of these things that are on the Internet, and other kind of things are very, very problematic for us. And some of them we're looking into and that kind of thing, but, they're not necessarily there. I did want to respond to the one thing you said about, how is this class of people going to know? And you mentioned the Presley case. And just to reassure you, that's something that when I speak on this matter, and there are many other people the Center for Social Media, there's a whole group of us and these organizations that are trying to really make our field aware of both what fair use is and its limitations. And we refer to that Presley case all the time and, present it to a group of filmmakers who would feel, if someone did that to them, they'd feel ripped off. So we're saying, now this is an extreme case, but it's certainly not that. So we're very concerned about this question of, where do you draw the line and that kind of thing. And the process that went into creating this document was to bring people together from our field all across the country. We hosted meetings in Chicago, and there were a lot in other cities, with lawyers and with people from the Center for Social Media, and we would have this dialogue about, how do we interpret the law and where do we see it? And and we found there was a point where people said, well, wait a minute, that's we don't want to go there, that's going too far. So this is what we've done a lot of work in this area, and in terms of the schools and the universities, this year alone, I've been to several schools. The last one was the university, Michigan State University at Lansing, where I spoke on this issue to documentary filmmakers students. So rest assured that this is rather a robust, we see this as an important part of, in a sense, reclaiming our fair use rights, because people really need to know what those rights are, and they also need to know what the limitations are and what's in the law. So, we put a lot of effort into that.
Can I ask a follow-up
Yeah.
question, just in terms of the public domain works? Can you give us just some idea of what kind of material, public domain material, you would need to get from a protected DVD? Like, for instance, what's coming to mind is something like newsreels or things that come up, and so is it just a matter of why would you need to get that from a DVD as opposed to maybe going back to source material?
You might not. For certain old feature films, they may not be things that are in the public domain, things from the silent era, might not be available in any other format. We often do, we often will go back to source material if you can get your hands on it. Another kind of example are things that are in the public domain. Really the only thing, because it's not a big element for our kinds of documentaries, it's more the historical documentaries where this is a big issue. But the one time that I did have experience with this was where I got, this was before CSS encryption, but we made a film called the Chicago Maternity Center film. We used footage from Prayer Lorenz's Fight for Life. The film was a government film, and it was in the public domain. And, it was a public domain use. I'm not sure if I could get it today. I could look into that and get back to you. But I know that a lot of stuff that other filmmakers use from the early days of film, from things that are in the public domain, from old news footage and stuff like that. Some of it is available and some of it isn't. Some of it is, bundled on these, these DVDs where someone has re-released it. This is actually a fairly common thing where people take something that they don't actually own, but it's not clear who does own it. They package it with new material and put a copyright on it and say, now, we own it. And in fact, the underlying piece they don't own. They underline the new material, the new soundtrack, whatever it is.
Okay, so Steve, let's get your response to that public domain issue, the notion of public domain material being bundled with copyright material and therefore protected by CSS.
Yeah, certainly that occurs, and my recollection is that this was an issue in the 2003 proceeding, and certainly didn't result in an exemption, but I'd have to go back and look at the analysis for it. We quoted in our submission, I think, the conclusion about public domain material, and I think it remains the case that circumventing something that access control that's been placed on public domain material is not a violation of the statute, so no exemption is needed. But I guess I would like to reserve, I'd like to go back and see what it was that the office said about that specifically in 2003.
I think the way that we see the problem is, we need the exemption because even though it's in the public domain, if you break the I think the way that we see the problem is, we need the exemption because even though it's in the public domain, if you break the encryption, that act in and of itself is what we're concerned about. So, for instance, in the example that Jim gave from Terra Incognita from the Woody Allen movie, where we did find this old VHS copy in a library, and Jim did all this magic, and we finally were able to get it to meet PBS standard and used it in the thing. Of course, I look at it and I say, that looks like crap. It meets the standards, but from an artistic point of view, from an aesthetic point of view, it really isn't very good. And particularly when you're commenting on culture and you're commenting on feature films are very sensual, they're very visual. You sometimes not, but sometimes it's very important to have in your film some of that quality preserved so that people understand that what's creating attitudes or creating emotions in people that we may be commenting on. We're saying, look at how, these Arab people were portrayed in Steven Spielberg's film, and it's high quality filmmaking that is affecting how they experience it. So we often want to get the highest quality that we can even though you might say, oh, it's a documentary, all you have to do is show an example of it. We actually need it to be, it doesn't have to be like high def necessarily. It doesn't have to be what you see in the theater, but it has to approximate that on some level.
Yes, Bruce.
I was just going to comment on the public domain. I think, if I'm recalling correctly, the previous discussion in the past centered on the fact that the basic prohibition of 1201A is no person shall circumvent a technological measure that effectively controls access to a work protected under this title. And if the work isn't protected under the title, the prohibition
Okay, so let's give you this scenario. You've got a DVD. It's got material that is clearly protected by copyright on it. It's got material that's clearly public domain on it. It's got CSS on it. So that access control is controlling access to a copyrighted work.
I think it does. But I think I do understand the sort of mixture or the bundling and that sort of thing. But if you had something which was pure, simple, straight public domain, I think the prohibition on its face doesn't apply.
So do we have a Steve is nodding, so I want to do we have a consensus from the people who are at least sitting here representing audiovisual copyright owners or the people who own this particular access control technology, that if somebody breaks through CSS on one of these DVDs that has both copyright protected material and public domain material, but does so only in order to get the public domain material, they are not violating 1201A1? That would be a very interesting concession and very useful for us.
What you held before 2003 was that it's not within the scope of this proceeding, because this proceeding only deals with adversely affecting non-infringing uses of a particular class of copyrighted works. So it's outside the scope of this proceeding.
That may be what we said. I'd have to go back to that, but I think you just ducked my question, Steve.
Let me say two things here. One is that what I was trying to distinguish was the case where you didn't have everything bundled and all you had was public domain.
Oh, sure.
Work.
No one's got a problem with that.
Well, okay. I just wanted to. That was the limit of what I was saying. I think the issue that you raised is a more complicated question. I would also say that as to the other prohibitions with regard to creating the tools and that sort of thing, you don't have even if there are some incidental public domain works that are protected, the tool is still prohibited because the primary purpose of the tool is to gain access.
All right. I think we all understand, and we've had this conversation a number of times in these hearings so far. We are not dealing with 1201A2 here.
Right.
Let's please try to stay away from that because it's not going to be productive for us to get into that. Now, Gordon and Jim, something I do recall from, I thought it was 2000, maybe it was 2003, when we did have people making the case or trying to make the case about public domain material being bundled on a DVD. I very clearly recall that after the hearings, we went back with questions, which you can anticipate you'll be seeing this time. I won't promise it, but I think it would be a good chance that we would, where we actually asked those proponents to come back and give us evidence, show us the magnitude of the problem, basically tell us to what extent public domain works are, in fact, bundled with copyright protected works that have access controls on them, and you can't get access to those public domain works otherwise. And my recollection, which may be faulty, is that in that prior proceeding, when we asked that question, what we got back was a very paltry showing, which certainly didn't persuade us several years ago. Maybe the situation has changed, or maybe we were wrong, and we can take another look at it. But I would imagine that to the extent you're asking for something on that, you may get a follow-up question from us asking you to prove your case, essentially. All right, let's move on. Steve, I think what I heard from you was in your suggestion that if we were tempted to recommend an exemption, it should be more narrowly crafted. We shouldn't refer to fair use or Section 107. And I just want to explore that for a moment, because I guess my reaction to that would be that putting that in the proposal, on the face of it anyway, narrows the proposal down. You're saying, look, you can only do it for this particular purpose, not for any purpose, not for any non-infringing use. And as you yourself have said, there are all sorts of non-infringing uses which are not fair use. So I would have thought you might be favorably inclined to say, fine, if there's going to be an exemption, let's narrow it down so we're only covering fair use. Granted, fair use is sort of a squishy thing, but nevertheless, at least it limits it. So I just want to make sure what you're really saying to us is, if there's going to be an exemption, please don't mention fair use. The byproduct of that being, I suppose, that documentary filmmakers might well be able to circumvent more broadly than they would be able to if all they could do was circumvent for purposes of fair use.
Well, they wouldn't be able to circumvent any more or less broadly because, as I know you have stressed in several of the previous proceedings, if in fact the use ends up to be infringing, it may be a violation. But our concern about this is that by defining an exemption in terms of a class of works used by certain people in a certain way, if it's fair use, we are very concerned about the short step, or maybe it's a long step, between 11B and 11A. 11B has a number of elements in it that attempt to serve as a proxy for establishing that the use will in fact be non-infringing, which is the standard that you're supposed to apply. 11A doesn't. And I mean, we actually had some of this discussion yesterday as well, but it's quite clear that one red line you can't cross is to say circumvention for the purpose of making a fair use. That is not an acceptable exemption in this proceeding. And so to say circumvention if A, B, and C are true and it's fair use, I think is a step toward that. So that's the basis of our concern about it.
Okay.
But isn't this an attempt really just to narrow the non-infringing use? I mean, it seems to me the only basis on which the claim is being made that in any case that this can be used, it's limited to a fair use claim on it. So it just seems to be an attempt to narrow the scope to.
Yeah, I guess so. But I mean, let's think this through. So if a documentary filmmaker who met these qualifications made this circumvention, but it turns out he wasn't doing it. He was going to make a movie, but the basis, it ends up being an archival copy in a library that's protected by where the exception is 108. Then this doesn't apply. I'm just not sure.
The documentary filmmaker would use the 108 exemption?
Yeah, I mean, I just don't see what kind of limitation this really imposes, frankly. I mean, you're right, the only non-infringing use that they've talked about is fair use. But the burden that they have to meet is to show that the uses that will be enabled by this exemption will be fair use.
Will be non-infringing uses.
Well, will be non-infringing. And the only example they've given is fair use. That's the burden that they have to meet.
Right, I would get it. Let's move on then. Question for Gordon and Jim. Steve talked about how there should be some kind of requirement of a good faith effort to obtain the material without circumventing. By that I gather what they mean is the exemption should be crafted such that you can't just automatically circumvent whenever you need it, but you first of all have to make some kind of a good faith effort to see if there are alternatives that would permit you to get what you needed without circumventing. Any problem with that?
It just seems to me that's one of those vague things. One of the issues now is that probably everybody knows that we could break the encryption and use this stuff. The reason that we don't is because it opens us up to a liability. So what would this procedure be? Who would be supervising it? Where would you? I mean, in what we do, we make a lot of good faith efforts to reach people for things that we need to license, for instance, and that becomes very difficult. But we, of course, do it. Jim described a situation where we were trying to use something for fair use, where we went to a lot of effort, to find a copy. We're researchers. We do that kind of work. But the idea of documenting it and that documentation then being a part of what is going to make this what we see, fairly innocuous activity, I know they see it very differently, of breaking the encryption, making us vulnerable to some kind of a lawsuit, I think that would be very, very intimidating, because it's like, what kind of records are you talking about? What constitutes a good faith effort? As I mentioned, in many situations, we have gone directly to an artist to say, we're going to use this in such and such way. We think it's fair use, but we'd like you to know about it, or, to be aware of our film. And often I'm seeking their, it just seems like the right thing to do. So I'm just confused about how something like that would work, what it would be, and what kind of vulnerability it would open us up to. Because the thing that we live in our community, one of our fears is what we were dealing with 5 years ago that was documented in the Center for Social Media's Untold Stories report, which was fair use was off the table. It wasn't being used except in the most, very, very narrow circumstances. Broadcasters weren't accepting, and it was really being used under the table. Basically, the contracts you were signing were saying everything has been licensed, everything in this film. You wouldn't mention it, but sometimes there was something that was more almost like don't ask, don't tell. And that was not a good situation to be in. And that came about because the very people who were saying, well, make a good faith effort to us and come to us and, somehow create some, which to me feels like now what's the next step? When's the other shoe going to drop? These are the very people who, in a sense, by being so aggressive, we perceived it as we lost the right to make fair use over the years as they threatened broadcasters, and we would get the letters too. Everyone was getting these letters. And now we've pushed back as a field. You're not all by yourself. And the broadcasters have finally gotten some backbone and said, no, if it's fair use within these defined contexts and you can get an opinion and the E&O insurance, we'll be happy to broadcast it. So I think that's, those are some of the problems I have with that, which is I just have a feeling that it creates a situation in which, they're concerned about one kind of slippery slope. That's the slippery slope that I'm concerned about, which is where we see all of a sudden a burdensome situation in which everyone is like opening themselves up to possible liability, which then we're not able to use our fair use rights anymore. And I think that is damaging to our democracy. We really feel very strongly that these rights are crucial to the, I don't really have to make the argument for fair use here.
Okay. Related topic, we've heard a lot from the other side about permission and how you should first have to ask permission. What if there were a requirement that was simply that? You have to ask permission. If they say no, fine, you move on and you circumvent. If they place conditions you think are unreasonable, then fine, you move on and you circumvent. But just a simple requirement that you ask. What about that?
There is no permission requirement in the fair use doctrine now.
Sure, but there might. Keep in mind, we're not talking about fair use. We're talking about 1201, which has no fair use provision in it. So.
I think, and when I talk to people about this, when I educate people, one of the points that I make is that if you have asked permission and been denied, if you said, can I use this material, can I break the encryption, well, that isn't the case that we're dealing with now, but in many situations, people will come to me and say, well, I tried to license this, they turned me down, now I realize it's as fair use, what do I do? And I always say to them, you have not weakened your fair use claim at all by asking permission. In fact, in a sense, it's not a bad thing to do, and we do it also. So I think that the thing that I would resist was having a permission requirement in it, but that in fact, as a part of our professional kind of what we do, I think that it's not bad to let people know what you're doing. It's not bad in some cases to seek permission to say we want to use this fair use. We're just letting you know. But fair use is, I see it, and the lawyers have kind of explained to me, so I'm a little confused. I use the word right. I see it as something that is a right, and that's why it's in the law. I guess there's a better legal way to say that. So that would be my concern with it. But it's obviously, as a part of our standard practice, it is something that we do. And I'm always trying to make people understand that it doesn't. It's fine. When we use fair use, we try to give credit and acknowledge it on the film. We want to put it in the credits and all of that kind of stuff. And that's really a change from 5 or 6 years ago, before we did all this education, because people were saying, "Oh, well, you never put it in the credits." And lawyers would tell you that. It's not just universities that we go to. We've been to the Copyright Society. We've spoken to all kinds of legal groups and to filmmakers. And, I think there was a lot of confusion out there that has become much, much clearer. Fair use is not as fuzzy as it used to be, at least in our field.
There's been some back and forth, and I just want to see if we can get any more clarity on it. Maybe not, but I think I heard you say, I forget now whether it was Gordon or Jim, and I think Steve reacted to that too with surprise, that you can circumvent in such a way that all you're doing is getting a short clip rather than putting the whole work into the clear. That's something that you clearly understand can be done?
We do it every day with non-copy protected materials. We're constantly re-editing, pulling clips from our own shows, and there are several software programs that do it directly. You can mark an in point and an out point. It can be as little as 1 second and as long as 2 hours, and you say extract, and it makes a new file that goes right into your editing timeline. Doesn't work with CSS disks, of course, but it...
I'm sorry, it doesn't work with CSS disks.
In other words, the program that we use doesn't work with CSS disks, and we don't pursue CSS disks.
Okay, well, let me ask
them. But there are programs out there that do.
Okay,
you don't have to take a whole chapter. You don't have to copy the whole disk. We never have a movie, a copy-protected movie, on hard drives sitting around to go into a library in 10 years. We wouldn't donate the disk space. We only take what we need and only what's going to be used in the show.
Okay, now Bruce clearly has a reaction on that, and Steve may or may not. So
I don't want to make a definitive statement, but my understanding of how these programs work that circumvent CSS is that it what it does is allows you to play back the movie, decrypt the movie, and store the entire movie on some storage device. You may then later go back and mark, I only want 30 seconds here or there, but I don't think that you can on the fly say, okay, I'm only going to decrypt and circumvent the 30 seconds, at the 90-minute point in the movie. I don't think that that's how they work.
Is it fair to assume, Bruce, that although you may not have actual knowledge of that, your organization probably has the resources to tell us?
We could get back to you.
I think that's an interesting question.
Because I can get back to you too.
Yeah, well, both of you, obviously, the more information you can give us on that, and let's assume for a second anyway that it is as you describe it.
Just give me a 1-day exemption, and I'll try all these things.
Well, if you want to talk to us, as I said.
As a general proposition, all of you folks, if you guys want to talk and come up with a unified position on anything, we'd be delighted, obviously.
If I could just clarify, because I think, correct me if I'm wrong, Jim, but it's like, I think the point Jim is making is yes, these programs could enable you to take the whole film, but the original, and I think what I'm understanding is the original DVD is still going to be encrypted. It's a way of playing it back and getting rid of the encryption, and in our field, we don't take the whole thing. We don't, we take, the piece that we're going to need because otherwise we've got it on a digital drive. We have to store the whole thing. It wouldn't even. I mean, drive space has gotten cheaper, and I suppose we could, but it's not our practice. We take these short pieces that we're actually going to be working with. And so I think that's the point. Is that correct?
Absolutely.
So assuming we get confirmation that it is possible to decrypt only that short portion that you need without, basically having an unencrypted copy of the entire work sitting somewhere, would there be any problem if an exemption were to issue, if we somehow were to include in that a condition that you are decrypting only so much as you need to decrypt for purposes of including it in your film?
No problem at all.
Any reaction on the other side to that? Reserving your right to object to the whole notion, but if we're going to go down that road, would that be something you'd like to see?
Yeah, I mean, I think that on the that's the kind of thing that adding to the list that Steve had. Again, if you're going to go down that road, that would be something that would be helpful.
Yeah.
As to that point, I'm just a little unclear. Are we talking about software that the documentary filmmakers get to decrypt it, or would it be possible for the DVD Copy Control Association to provide a key to a limited portion of a DVD?
No, I mean the way the encryption works, if you get the keys, you're capable of decrypting the entire work. So there's not. In some very sophisticated encryption, I understand that the key changes over time during the course of the work. That's not how CSS works. So literally the answer to your question is no. We couldn't do that. There may be.
Well, then we'd know the answer then to the rest of this, right? Because if there's no way that, at least that you know of, to do that, probably that's the way CSS is structured rather than any flaw in any other software
Right.
Jim?
But it has to do with the user. In other words, if we as an organization only pull out the clips that we need, then we can swear legally under oath that there is no copy of this movie on our facility, and there never has been one.
There's no question of that. We're just trying to clarify, is it technically possible to
isolate it?
To decrypt portions rather than decrypt the whole thing and then choose portions of it? And just one in relation to that as well, then I guess maybe this is answered by that, but Bruce, you had made the statement, documentary filmmakers have not come to you to ask about this. What could you have done had they come?
I can't speak for the board of directors and the officers of DVD CCA on what could be done. What the point I was making was that if somebody came and said, this is what I want to do, is there a way to license, and I don't mean license the content, I mean license the technology such that it does X. That is something that would be considered. Now, whether I can't say we would agree, and I can't say that the conditions that might be worked out would work for everybody. But it is something that if somebody came and said we want to do X, can we find a way to use your technology to do that? And as I said, as I've said before, I think we would prefer if it was possible to have that dialogue rather than have a sort of widely available public exemption from the circumvention. It's better for the technology.
That would still require a couple steps. I mean, DVD CCA could not speak to the specific content.
No.
It would just be as to that technology, and then it would have to relate to the underlying content that is particularly at issue.
There are a variety of layers that where one could get tripped up. I mean, there's no question about it. But purely as a matter of could we use the technology, on a licensed basis in this way, as I said, no one's come and asked.
I think I just want to say that I think that would be problematic for us because ownership should not determine what you can use and what you cannot use for fair use. And I understand the question about the technology, but I guess what I would say is if your concern is that we're taking these unencrypted pieces and they're around on our hard drives and that kind of thing. It's like, well, then you come to us and we'll work out a solution so we could say, no, when we take the pieces, we make sure that it's erased. What do you need to be assured of that? But it's what I'm concerned about is this thing that always comes up, which is, there must be a marketplace solution for this, or there must be a technology solution. We're talking about a fundamental free speech right. And that needs to be protected in that sense. And so there can't be all of these, well, if you just ask or if you just do this, it gets very, very complicated. I mean, you were all aware of the kind of thing when you go to try to license news footage, and they say, well, yes, we've given you the license to the news footage, you've bought that, and blah, blah, blah. But, of course, if you want to use the newscaster, that's a separate contract, and you have to go and talk with his agent and get permission to use his footage. On the other hand, if it's fair use, and you're using it in a legitimate fair use way, you don't have to do any of that. All the underlying rights are covered. So I think that's just important. We have an interest in not creating a situation in which people are infringing upon this in illegal ways. We don't want people being able to, steal copyrighted material to use in ways that are not within these narrow confines. And if something we're doing is creating that situation, well, then come talk to us, because we don't want to be a part of that.
I would only remark that as far as the First Amendment, the Section 1201 has been evaluated, and the protection against circumvention has been upheld as against people's challenge that it infringes free speech.
Okay, one final question, then we have to move on. I heard from Steve another condition he'd like to have thrown on this, if he's so unfortunate as to have an exemption granted, would be that it only be available when the access control in question is content scrambling system. Is that something that you folks would find acceptable? Or Jim is nodding yes. Okay. Mm-hmm. Okay. All right. I've got a lot of other questions, but we have other witnesses, and I think we need to get to them. So the rest of my questions may get asked later on in the general Q&A, or we may just have follow-up questions in writing as time is moving on. So let's move on to our next witness, who is Rebecca Tushnet of the Organization for Transformative Works. Rebecca?
Hi. So my name is Rebecca Tushnet. I'm professor of law at Georgetown, and I'm a member of the board of the Organization for Transformative Works, which focuses on protecting fan-generated works, which are usually based on existing copyrighted works, although sometimes works in the public domain. They are non-commercial, which means that they are labors of love, quite literally. They often involve substantial investments of time and energy, sometimes even money, and people get nothing back except the satisfaction of creating and whatever effect they can have on the culture having created these works and responded to pop culture, sort of talking back to popular culture. We're here in support of the exemption 11A, the exemption proposed by by the EFF for audiovisual works on DVD, where circumvention is undertaken for the purpose of extracting clips for inclusion in non-commercial, fair use, non-infringing video. And the thing is, the adverse effect on fair use and on non-infringing use that the exemption addresses is on the system of fair use. The technologies at issue here are important because they're readily available to individuals and to a layperson, especially to the artists who are inventing remix culture, often in their own homes. They are not distinguishable from other readily available technologies. The current regime is a trap for the unwary, and it crushes the development of the very fair use jurisprudence that the opponents tell us we must have before we can get an exemption in the first place. The joint commenters have conceded that there's a substantial amount of non-commercial fair use done by ordinary citizens in dozens of different contexts all around the country. By definition, it's non-infringing. The statute requires us to show an adverse effect on that. Once we have shown an adverse effect, which I believe we can, an exemption is on the table. To say otherwise is to say that there are certain types of non-infringing uses that the statute categorically refuses to consider, which I think is inconsistent with the statute itself, especially when it comes to fair use. And again, we are being deterred from getting precedents from Article III courts on what is a fair use because the people creating these works can't go to court because of 1201. It's a catch-22. They say we need precedent to be sure it's fair use, and we just can't get that. The exemption here is limited to a class of works where there is a demonstrated problem. Works on DVD, not Blu-ray or other media. It's limited to a class of users with particular difficulties, non-commercial clip makers who are in the worst position to know the distinctions between technologies the opponents think they should be making. I want to address the question of why circumvent. We've heard that convenience should not be the standard, and I agree. There's nothing convenient about what's required to do this. Yesterday's distinction between inconvenient and abnormal is really useful. It's abnormal to distinguish between methods of getting a digital file, and it's no wonder that the fair users with whom we talk and who get takedown notices and want to respond to them and then conclude that they can't because they can't tell you exactly where the clips came from. They don't know they've walked into a trap. We've heard from the joint commenters the best copyright lawyers in the business are unprepared to answer the question of whether Snagit is a circumvention tool. A non-lawyer is in absolutely no position to understand what the law supposedly allows them to do and not do. And it makes no sense to tell them that one method that produces a digital file is okay, while another method that produces a, worse, but basically similar digital file is okay. The Copyright Office apparently is not prepared to tell us what technology you can use. That's a huge barrier for an artist who does not have legal counsel on hand. Now, it may be true that an institution with substantial and varied technological resources can figure out workarounds to this. But individual citizens who are creating fair uses for political purposes, we saw that lots in the Obama campaign, sometimes even in the McCain campaign, that they're participating in cultural exchanges. They don't have AV departments. They can't go to these workarounds. What I see here is essentially a digital literacy test and a digital poll tax. The literacy test, as you may recall, required prospective voters to interpret an often arcane provision of the law. Here, the test proposed is that they understand that a digital file created one way, okay, while a similar digital file created another way, not okay. Then there's the poll tax. You have to purchase the proper equipment to create the second digital file. It's expensive. It's non-standard for an individual artist. We were offered yesterday the prospect of using a $900 camera, plus a tripod, which, by the way, I priced $300, plus a flat-screen TV in a room that you can make it completely dark. Do you think you can do that in the average home? You can't even do that in the average school. I was trying to think of a place in Georgetown where I would be able to make it completely dark and also put the camera far enough away to get the right distance, which, as we just heard, is very important to getting the right file. I don't think it could be done at Georgetown. Certainly couldn't be done at home. The non-commercial artists that we work with are often pink-collar workers. They work to support their art, and they work to support themselves. $900 is regularly more than a month's rent for them. It's crippling. And they don't get paid for the works they create. They can't call the $900 camera an investment. They can't even deduct it. It's because they're engaging in free speech. They're not running a business. The poll tax, too, is inherent in the responses from the opponents when they argue that the camcorders somehow preserve the technology differently than the technologies we're talking about. That presumes that the camcorder solution is the one that won't be used by fair users, and therefore fair uses will be suppressed. To the contrary, I think the possibility of camcording proves that the proposed exemption won't cause any harm. They say camcording is easy and it's good enough to watch. Well, that's true. If that's true, that's what the pirates will use. You can't both maintain that camcording is a substitute for fair use clipping and also that the exemption will degrade protection for CSS compared to camcording. We got rid of the literacy test and the poll tax because they deterred people from participating, people whose voices weren't heard otherwise. We did this even though there were people, brave people, who defied the laws and persevered. Some even managed to register and vote. The problem was, and it was quite clear, was all the people who didn't make it through all the hurdles. That was understood as a harm to the political system. And it is so here as well, especially when the voices we're talking about suppressing are the voices of precisely the people who do not have mass media outlets, who get attention, who get heard by responding to what they see and critiquing it and saying, by the way, this doesn't represent me. Look here and then look at the way that I see it. The key here is that distinctions between output files should make sense from the perspective of an ordinary user. Fair use is actually a reasonably intuitive concept, as is the distinction between transformation, which is what we're talking about here, and pure copying. Interestingly, the Center for Social Media, which you heard about their best practices, which have been incredibly helpful to documentarians, they also have a series of best practices for online video remix, which goes through and says, look, fair use is understandable. You can learn to use it. You can learn to use clips. Right? You can learn to comment on them. It's not impossible. It's nonsensical, however. It's even contemptible that one way of making a fair use remix is okay and the other is not. The last thing that copyright law needs is another rule that doesn't match up with ordinary people's intuitions about what is legitimate to do and what is unfair and can only be done with permission. The current situation deters risk-averse remixers from making fair uses, because how do you know you did it okay? And the ones who continue find themselves unable to assert fair use defenses for fear of DMCA liability. So this Fred von Lohman of the EFF testified about this in Palo Alto. We've seen this at the OTW in our conversations with remixers who get takedown notices. They want to make fair use claims, but they decide that they can't because they don't know about the method they use to capture the clips. They're afraid that it's a circumvention. And this has a substantial effect on the development of fair use jurisprudence. It's just basically it's arbitrary and even cruel to tell non-commercial fair users who do want to fight for their fair use right that it's too late for them, that they should have gone to law school before they started remixing, and we can't get the precedent that they want to defend themselves because they're likely to lose on a 1201 claim regardless of whether they have a fair use. I want to speak to the issue of enforcement concerns. The proposed exemption only applies if there's an underlying fair use. Copyright owners are free to challenge anything they don't agree is a fair use. We welcome the opportunity to develop fair use jurisprudence in the context of non-commercial transformative uses. And here's the thing. None of these commercial creators, let's assume that counterfactually, that they knew the law and could read the 6 pages that the DMCA takes up in my statute book. No non-commercial creator would say, I know this isn't fair use, but the prospect of statutory damages, because let's face it, they're all registered. If you get a threat letter, they will all threaten you with 6-figure liability. Right? I know it's not fair use, but statutory damages aren't enough of a deterrent. Only the additional prospect of DMCA liability is enough to prevent me from infringing. That is a nonsensical way to think about it, and indeed nobody does. Any extra deterrence supposedly achieved by the absence of an exemption is only achieved by deterring fair uses. And frankly, I don't think the statute requires the public to subsidize copyright owners' enforcement decisions by deterring fair uses. The enforcement concern, of course, is mistaken in other ways as well. As the joint commenters readily concede, these technologies are widely available and widely used. What is it exactly that we're trying to deter? That's also not as important as the bigger point. These technologies are not great ways to infringe. They're great ways to get clips. So just by way of example, downloading a 700 megabyte movie at 2 megabytes per second, which is a fairly standard broadband speed, I bet you could get it in this building, takes 45 minutes. It's less time than it takes to rip specially chosen clips. When you're ripping clips, you actually have to pay attention to what it is that you want. You could even, if you were inclined to do so, rip a high-quality version of a whole movie faster than you can get clips. This ties back into the point about making the law comprehensible to ordinary people. When we talk to these artists, they say, are you seriously telling me that it would be better for me from a liability perspective if I had downloaded the whole movie instead of, as I did, paying for the DVDs and taking clips from them? No wonder they don't anticipate that before they get the takedown notice. It doesn't make sense from a very intuitive sense of what is fair to the copyright owner. It makes sense. You pay for the DVDs, right? They get the reward. and you make a non-commercial remix, you're not harming them. You're certainly not putting full copies out there. And yet somehow you're in a worse position than somebody who just downloaded the whole TV series. I want to take a moment also to talk about alternatives. Now, the basic proposition that I want to communicate is that people don't know that these alternatives have different legal consequences. So the law as applied to them is essentially random. But let's take a look at some of these alternatives. So for example, screen capture software. We would like very badly a real answer from the joint commenters about their perspective on this. We do note that if using a camcorder on the screen, pointing it on the screen is not circumvention, we find it hard to see why having the camera embedded in the computer is any different if it's capturing the same output. And I think Rob Kasnick pointed this out. However, screen capture doesn't produce clips of sufficient quality to make the artistic point that our artists often want to make. Other people will testify about the importance of high quality to remix artists. I would say we would not tell other artists that they could only use crayons and not pencils, or paraphrases and not quotes. We would think that that actually interfered with the art, the result. Here's an example of how quality is important in political, critical remix video to show you things that aren't easy to see in the original. There's a video called How Much is the Geisha in the Window? It's about a science fiction series, Firefly, by Joss Whedon, very popular among certain segments, made a fair amount of money, enough to get a major motion picture made as a sequel. Firefly is supposedly set in a future where Chinese and American cultures are roughly equal. They've had roughly equal influence on the far future society. The characters speak Chinese phrases. The set decoration is consistently Asian influenced. There's lots of detail. And yet, somehow, all the main characters are white. Right? So the remix video pulls out in the background the occasional Asian extra and the set dressing details and the part where they eat dogs in their charming, Asian way to show exactly how orientalizing and disrespectful of the culture the series actually is. Those details are exactly what are lost if you have to do something in low resolution. It doesn't help the critique to say, okay, well, all these pixelated background extras look pretty much alike. You can't see the point, which is that there are all these white faces and then only a couple of Asian ones in the background. All of the suggested alternatives, in the end, limit the source materials people will draw from in various ways. And the point I want to circle back to is that there are a wide range of people creating out there, a wide range of creative practices. Potential fair users are being discouraged and will be discouraged because they misunderstand the distinctions between technologies. Without an exemption, the rules distinguishing technologies are arbitrary because they don't relate to the nature of the artistic activity, which is the output. Any rules should be directed to what it is that you're making, not the way in which you made it. A separate point about screen capture software, as you've heard, it doesn't actually work on many systems and with many DVDs. I know this from personal experience, trying it out, as well as with conversations with others. As it appears, content owners are using mechanisms to prevent screen capture software from working. Vista includes new technical protections meant to stop this from working in the future called the protected media path. It's actually put there at the insistence of the MPAA companies as a condition of making formats like Blu-ray available. One of the stated design goals of the protected media path was to block screen capture. It's already deployed in every Vista PC that's shipped and every one that will be shipped in the next 3 years. Just as neither institutions nor individuals should be expected to hang on to their VCRs forever in order to take advantage of obsolete technologies, neither should we be expected to hang on to our old operating systems. And remember, we are talking about people who are not institutions. They have one computer. In fact, I think it's probably true that the studios and their partners have a very strong incentive to implement additional measures to block screen capture. Screen capture makes all formats vulnerable. A DVD exemption is actually a much more targeted way of addressing the current problem. I want to let other people talk about quality, but I do want to say a little bit about the fact that some of the discourse here has seemed to be that you got to be this tall to make a fair use, right? That fair use is for people who, are educated, are in certain professional positions, and yet fair use is political. It's cultural. It's the way that you talk back to the things that you see around you every day. If we require people to have professional affiliations or other credentials before we allow them to make fair use, we will get a different kind of fair use, and one that does not reflect what our citizenry is and what it should have the right to say. Thank you.
All right, let's hear from Francesca Coppa.
Hi, I'm Francesca Coppa. I am not a lawyer. Rebecca is the lawyer for the Organization for Transformative Works, but I am on the board, and I am also Director of Film Studies at Muhlenberg College. The OTW, as Rebecca has said, the Organization for Transformative Works, advocates for groups of fans making transformative works, which include remix in the broadest, many different forms of remix. I'm not an expert on this statute, but I am an expert in practice. I'm here representing certain kinds of practice communities. One of the things that I think is important to say about the remix practice community in general is that remix stems out of minority cultures. Historically, remix is practiced by minority groups, women, various other kinds of ethnic minorities, people of color, and GLBTQ, gay and lesbian, transgender, bisexual folk. And of the sort of people who are interested in our organization, the people we see making transformative works are almost exclusively women, minorities. I literally know very, very few straight men who are doing the sort of remix that I'm here to talk about. My specialty within this remix culture is vidding, which is a predominantly and distinctly female form of filmmaking. Filmmakers are still underrepresented in film schools and nationally. But this is a heavily female-dominant form of remix. It is in this grassroots filmmaking form, clips from television and film are set to music and radically recontextualized, often to celebrate, but more often to critique and get you to kind of re-see popular culture. A vid in that way is a visual essay that talks to popular culture in the same language of the original. It's a visual essay on a visual source. This practice of speaking back and the making of vids, which has been going on for some time among women who have a fairly strong community around this, is a form of art making and a form of cultural commentary that does not happen inside the academy or in high art circles, though vidding has recently been getting a lot of attention and respect in high art circles. We currently have a vid in the California Museum of Photography, asked to include a vid. New York Magazine singled out vidders who are real artists as well as really savvy cultural critics as having made some of the best remix videos of a particular year, so that there is a kind of high art. I've written about vidding for Camera Obscura, Cinema Journal, the kinds of practices that women do when they vid are very analogous to the sorts of collage appropriation art, remix culture that are currently found in major museums. There are pieces in the MoMA done by recognized high artists that are, I would say, less sophisticated than many of the vids that come out of the community that I represent. So there's a real continuity with digital art, and people in kind of the recognized cultural positions are paying attention to that. The OTW has a test suite of vids online at our site, which is transformativeworks.org. Let me give you one of the reasons I'm not showing vids. Vids are often made for to be shown in premiere at live gatherings on screens much bigger than this, are made to be shown often in kind of theater-like settings on very high screens, and made in very high resolution as a form of art for reasons that I'll explain when I talk more about what they do. Vidders who usually a vid will premiere, or often a vid will premiere in a kind of live venue at a premiere show, and then the vidder might subsequently offer a high-quality file for download, a high-quality file being sort of like 90 or 100 megs. a vidder might then put a streaming version online. Some vidders will not put streaming versions online because the quality is so degraded that it won't show what they want to show. Those who do, it's sort of like an ad or a preview, will put some sort of streaming online to sort of say, if you like it or you think you're going to like it, then you download the file. And so the quality is really a fairly large issue. Why is it a large issue? Let me talk a little bit about what vids do. Rebecca's already mentioned how much is that geisha in the window, which, as many vids do, vids often recontextualize pop culture to emphasize the subtextual, the marginal, the thing that was not at the center of the frame. To the extent to which this is a minority speaking back to culture in the broadest sense and representing a kind of alternative point of view or a talking back to culture, saying that the mainstream culture does not represent your position, you are often not focused on the most predominant thing, but are doing something like bringing the background to the foreground, drawing attention to something absent, missing, marginalized, constructing a reading that is not the most obvious reading. And so the idea of having a high-quality file is fairly important because you are often recutting and recontextualizing clips in order to emphasize visual patterns that were precisely not apparent in the original, in order to construct a kind of subversive or against-the-grain kind of reading. So a vid like How Much Is That Geisha in the Window is, as Rebecca was explaining, right, paying attention to exotica and the way in which actually human beings are treated as exotica in the background of Firefly, and what is ostensibly supposed to be a Chinese Creole culture that features no actual Asian people. A vid called Women's Work, which was made in the fandom Supernatural. Supernatural is a show about two brothers who fight demons. The vid Women's Work features no sign of these brothers. It edits together footage of the occasional female characters, most of whom are there to be murdered so that the brothers can then track down the monsters that killed them. So the women's work of the vid is in fact to be tortured, frightened, scared in various ways in order to provide the pretext. And of course the show then, I mean, as in much horror, the show will provide women suffering as a kind of, cost of doing business, right? I mean, well, of course a woman's got to be killed in the first 3 minutes so the detective can solve it. But by editing these one-time only characters into a series of montages, you are drawing attention to something that is supposed to be background and bringing it to the foreground. There's a vid called Wouldn't It Be Nice that looks at a whole series of buddy cops, paired male protagonists on television to make a gay marriage argument, essentially sort of reframing all of these various couples from the whole history of television. And when I say couples, I mean guys and their partners, guys in their second-in-commands, various forms of male friendship as depicted on television, and recontextualizing them as if, wouldn't it be nice if some of these couples were couples? Wouldn't it be nice if there was some recognized way, in particular, the vidder was talking about gay marriage, to recognize these relationships. There's a vid called Martina, which was made about Veronica Mars. Veronica Mars's third season, had the character who we know had previously experienced this sexual assault tracking down a rapist. And many fans of that show felt that it was and I say fans of the show, people who love the show, to make a vid about a show, you have to care about the show. You've watched it all. The critique you're making is a critique of somebody who loves it, has bought it, is interested in it, and still has problems with it that they want to articulate to a group. But Martina was sort of saying, was artistically trying to articulate that they felt that the show was being insensitive to the way the character would likely have reacted if she had actually been asked to track down a serial killer, given her contextual own history of abuse. In any case, as I say, all of these vidders are both cultural critics and, as I say, very, very fine artists. Tisha Turk will talk about some of the things that vidders do with footage. They don't simply watch footage, they're making things with footage. I'm talking primarily about the ways in which vidders strategize to draw your attention to things that you were not supposed to see or were not prominent in the frame before. So in this way, it's a different version of the kind of examples of yesterday where they were talking about a chair, right, that you have to have it fairly clear so you can see if such and such a chair is infringing. The kinds of readings we do, it tends not to be, it may be a piece of furniture, as in How Much Is That Geisha in the Window, an oriental vase or a exotica, but very often it's facial expressions, other kinds of subtextual or background characters or ideas that are brought into the foreground. So what is our problem? Right? Where's the harm to our community? Part of it is that VIDDers right now communicate through a series of online tools, social networking tools, YouTube, iMeme, streaming video sites. Increasingly, often due to algorithms, material is subject to random takedowns. YouTube did a giant purge in January where they just took down tons and tons of things and claimed that they were infringing. Other sites also will do random kind of takedowns and cease and desists, et cetera, in the kind of social networking sites where people communicate. Many of them provide, YouTube, for instance, provides a mechanism for disputing that takedown. And one of the things that the Organization for Transformative Works has tried to do is to say, if your video was taken down and you think your video is fair, I should say that we believe that this is fair. We believe that vids are fair use. Vidders, the people who are doing what we are saying, are making non-infringing, culturally relevant, artistically beautiful, fair use works. And we're saying, if you are making one of these, dispute it. Say, I am not just putting up some infringing clip that is piracy, dispute it. And we're finding that because of the lack of clarity about the methods, that we're getting some people who will just say, I don't want to dispute it because, yes, I think my product is fair, but I may have done such and such and such to get it, to make it, and so I don't want to open that can of worms. I had a particular exchange in my capacity as communications chair of OTW where I encouraged a woman to dispute, and she said that her daughter had made the vid and she wasn't sure what she had done to get it, and so she didn't want to fight the takedown. And I think OTW feels very strongly that it is important, and again, we're not talking about non-infringing uses. If you're pirating something and it's illegal, that's not what we're talking about. But that to the extent to which you've made something fair, that your ability to kind of defend your artwork and claim for its right to exist, to be seen, to be shared, is important. And I myself, have started to write about vidding because these are people who are not particularly capable of putting themselves forward anyway. To the extent to which they represent marginalized positions, to the extent to which they are making vids partly because they do not see their views reflected in popular culture and feel that their position is already marginalized, it's already kind of difficult to say, no, really, your speech is valuable. Really, what you have to say is an acceptable thing to say. Stand up and defend yourself against a corporation. Vidders historically, largely because they were female, kept their head down, were very, very nervous about sharing their work online, and in fact, really have only kind of begun to sort of peep out into the kind of more public spaces of the internet because they saw male forms of remix culture doing it. Forms like machinima, which is remix culture, films made inside video game engines, and other kinds of parody, Brokeback Mountain kind of fair use video. And I think the women of the community I represent said, well, they're not ashamed of what they're making. Why am I ashamed of what I'm making? But this is not a group that has historically been able to kind of put itself forward, and we see that as a real form of harm. In addition to the fact that, already you have people who may be nervous about kind of asserting their perspectives, and again, the lack of clarity about, I can't even tell them clearly what kind of method would make for a fair use. Rather than one. I can tell them what I can tell them what a transformative work is. I can tell them if their product is sufficiently interesting, critical, transformative, right? But it's much harder for me to tell them what method they would need to have used in order to feel safe protesting the work. And it is also hindering a little bit some of the recognition of this art, by the mainstream. Lastly, in terms of the image quality, I do think it would be a shame, aside from the practical issues that artists will talk about, if vidders and other cultural critics were first forced to work in degraded images. That one of the things that you do when you try to talk back to culture, if they have all shiny, big, luscious-looking footage, and you have to speak back in a degraded kind of a form, your critique is already, marginalized by its position. But the idea that then you're almost being forced to create your response in a degraded way seems very discouraging. So, thank you for letting me testify.
Thank you. Let's move on now to Tisha Turk, whose name we heard mentioned once or twice, I think, already.
I try. I teach English at the liberal arts campus of the University of Minnesota. And one of my areas of academic expertise is novels that rewrite other novels. And from there, it's just sort of a short sideways step to video that rewrites other video, which is my new research area. And you can ask me about that if you would like. But I'm actually here today as a remix video artist. So I want to talk a little bit about what we do and what we don't do, and why I support the proposed exemption 11A that was submitted by the Electronic Frontier Foundation. I want to start by emphasizing that remix video doesn't harm copyright holders. And frankly, from my point of view, it doesn't really hurt DVD copy control either. I'm part of the community that Francesca has been talking about, the remix video community known as VIDers, which is the community specifically discussed in the exemption proposal that was submitted. VIDers are good consumers. We're terrific consumers. My DVD collection is pretty impressive, especially for an English professor. I think we're supposed to be above watching TV, and yet I own a pretty staggering amount of DVDs. I have all these shows and a fair number of movies, and in a lot of cases I have these DVDs because at some point I saw a remix video made by someone in my community, and I said, that looks neat. I think I'll go get that and watch it, and possibly watch it many times, and possibly make my friends buy it as well. Sometimes the remix videos make the source look more interesting than it actually is, but that's fine. I'm okay with that. So when I hear the argument that allowing circumvention will somehow harm the copyright holder, I find it a little bit funny. I mean, I have circumvention technology, and I know how to use it, and yet I have a lot of DVDs. I mean, I still buy DVDs. I like DVDs. It's what I do with source that I enjoy and source that I want to work with. Sometimes I buy it multiple times if that's required. When I make and when I release a video, I am encouraging other people to buy the source material, to say this is worth watching, this is worth engaging with, and you should have this, you should care about this too. Vidders are cultural critics, as Professor Copa has mentioned. We offer criticism and commentary on media texts, but we're also artists. I mean, if I want to write an essay about a visual narrative, then I write an essay about a visual narrative. I have done that. I mean, I've presented academic papers on Buffy the Vampire Slayer, on Firefly. But other times, I want to work in the same medium as the visual text. In order to say what I need to say about that text, I need to comment by juxtaposing images. I want to create something that embeds a critical commentary within artistic expression in the same way that we sometimes have literature that is political, right? You don't just write an op-ed piece. You do something that accomplishes something both creative and political. It's not a new or an unusual impulse. I mean, we see it. We see it in literature. We see it in film. We see it in the visual arts. It's a big part of what I study as an academic, and it's also a big part of what I do as a video remix artist. And because the kind of video remixing that I do is an art form, quality is important when I'm manipulating clips. Part of yesterday's discussion centered on the question of whether all digital copies are created equal. And from the point of view of a video remix artist, the answer is a resounding no. And I want to make an important distinction here. As a consumer, I don't always need the highest quality for its own sake. I do my fair share of watching TV shows on my laptop using the Netflix Watch Instantly feature. That's fine for certain kinds of consumption of cultural texts. It's not ideal, obviously, in the same way that watching a particularly exciting movie with lots of explosions is not the same on your TV at home as it is when you go to the theater, which is why a lot of us still go to the theater to see movies. I mean, it's not an identical experience, but it is sometimes good enough just for purposes of consumption. So when I'm watching for the story, when I'm trying to decide whether I want to buy the DVD, I might use that sort of good enough kind of source. It's the same kind of thing as, I buy a lot of CDs. When I walk to work, I listen to MP3s on my iPod because it's more convenient, right? I mean, those are not mutually exclusive things to want. But when I am working as a creator, not as a consumer, but as a creator, quality is important. It's very important. I need tools that work. Much of the time, I'm not using the clip exactly the way it is in the original. The work that I do is transformative, and often that means transforming the appearance of individual video clips. So some of the things that I might do in the course, and I should emphasize here that I am not the most tech savvy of the video remix community that I represent. I mean, I would put myself in maybe the 60th to 70th percentile of people who really know how to manipulate source, and that's what they do. I don't have a background as an artist, right? I'm a professor. I'm a professional nerd. I don't have any training with the video stuff. I listen to Jim talk, and I have so many questions to ask him because it's fascinating. But things that I might do in the course of making a particular remix video. I might need to change the speed of clips. That's a really common thing, something that I have to do a lot in order to make things line up with music, in order to emphasize a particular thing within a frame. That, if it's a very short shot and I need to show more of it, I might have to slow it down. If you're working with something like the Snagit clip that we saw yesterday of "Oh Brother, Where Art Thou?", suddenly it goes from being slowed down to being jerk, 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 jerk. It literally does not look the same. You cannot slow down or speed up footage that looks like that. Again, it might be good enough to watch if what you want to see is what happens to the George Clooney character, but you can't work with it. Things that I might want to do, alter the color of clips to create a particular mood. I mean, again, I think of that example yesterday, "Oh Brother, Where Art Thou?", where the clips themselves, I mean, the way we see it, they've been desaturated, right? Things have been done to that source to make it look in a particular way, to create a particular mood. Say I want to tint everything in a remix video that I'm making a sort of metallic blue-green to create a particular effect, to produce a particular mood. We all know that color does that kind of work, right? If I'm working with source that is garbage, I can't do that very effectively. If I'm trying to match colors from two different episodes of a TV show that may have been shot with completely different lighting, I have some tools at my disposal, but if the source that I'm using is a mess, the tools don't work. I cannot do the thing that I am trying to do. I might need to adjust the contrast or the light levels of clips. I mean, there again, if the source is a mess, it doesn't work. I mean, things turn. Look, what is that beige blur in the corner? I think it's a face. I don't know. I might want to crop clips in order to focus on particular elements. And if you're working with something that is already quite low resolution and suddenly you need to crop out the outer, say, third of the frame in order to see more closely the fact that these two characters are holding hands, or the fact that there is something going on in the background or off to the side, I'm already, if I'm working with a really high quality image and I zoom in on it or I crop it, I am already losing some resolution. If I am working with a frame that is messy to begin with, I may have gone from good quality to still visible. Instead of that transition, I'm going from you can kind of see it to I have no idea what's happening here. So that kind of cropping or zooming to direct a viewer's attention to particular elements, these are things where quality really matters. It's not just, I wish it were prettier. It's that you really can't tell what's going on. So as I hope this litany of things that I want to be able to do to the source has shown, I don't want to rip DVDs because it's convenient for me. I mean, we've heard several times that convenience cannot be the standard. Nothing about what I do is convenient. I mean, this is work. It's boring. It's annoying work that in order to make the point that I want to make, I have to go through all this sort of bureaucratic and technical stuff. I want to rip DVDs because if I don't, I'm likely to end up with a muddy mess and then no one can see what I'm trying to say, in which case, why make it? I mean, I can sit at home and rant if I want to, but there's no point to that from a communication point of view. The clip from "Oh Brother, Where Art Thou?", the one captured with Snagit. I mean, it's watchable, I guess. I mean, the flicker would give me a headache. I couldn't watch it. I guess you could. My impulse would be to go buy the DVD and put that in my computer and watch it instead. But there's no way that I could use that clip for the kind of work that I do. It's jerky. It's pixelated. If I try to turn it a color, I don't know what's going to happen to it. One of the first rules of video editing, garbage in, garbage out. You start from messy source, best you're going to end up with is a mess. And if my video is that much of a mess, then I can't make the points that I want to make, either because people just won't watch the video. They'll hit play and say, what is this? This looks like crap, and, turn it off. or they literally won't be able to see it. So for my purposes, something like that is not an equivalent alternative to circumventing encryption. It might be if I were just consuming, but it's not if I'm making something with that source. So for me, not being able to circumvent encryption, not being allowed to or not being supposed to circumvent encryption has adverse effects. Effectively, it criminalizes my creative process. Something like camcording, I was very intrigued by the demonstration of that yesterday. That has adverse effects in that I can't do it. It's counterintuitive, it's impracticable, it's expensive. I mean, I'm sorry, but $900 that's 2 months of my mortgage. And I'm a professor. I'm the upper end of the people who are doing this kind of thing. We didn't even get to how much the flat screen TV cost, which I was really hoping to hear about. I mean, if there's a sale, I want to know about it. So that kind of process limits my ability to comment on the cultural texts that I care about and that I, at the same time, want to comment on. And I want to reiterate a point that Professor Tushnet made at the beginning, which is that I think the videos I make are fair use. But right now, because there is no positive law on the issue, I can't know that. There's a limit to how much I can assert that, and we can't test that in the courts unless this exemption is granted. Thanks.
Thank you. Our final, final witness is Martine Courant-Reif, who we've heard from yesterday, and we're hearing again from today.
Hi, thank you very much for having me here again, and I'm going to be very brief. I'm incorporating all my testimony from yesterday by reference, and I'll just briefly introduce myself again. And I'm Martine Courant-Reif from Michigan State University and Lansing Community College, and I've been studying the impact of copyright law on digital writing for the last almost 4 years. My PhD is in rhetoric and writing, and I'm also a licensed attorney in Michigan. Yesterday, I offered language to attempt to limit the exemption in a way that would include both students and teachers' coursework as well as work for and with community groups. I'm concerned about this area where students are working with outside groups, and I'm asking that if and when you craft the exemption, that you would take this into consideration. I hope that my students who are producers of texts, that's the main goal of a writing classroom, my students produce texts. I hope that the skills that they learn in my classroom can be used after the class is over, and so that's why I'm here today. It is common for writing classes to work with nonprofits and community groups, such as, for example, the Capital Area Community Media Center in Lansing, Michigan. A number of students at Michigan State University work with this particular community media center. They try to help these types of groups craft educational materials that can assist with community literacy. And the Capital Area Community Media Center in Lansing, Michigan lists other community media centers around the United States. So this is a type of organization that is developing due to the digital age. I would like the exemption to cover uses where students are working outside the classroom. And I work at a community college, and likewise I am very interested in how the work I do in my classroom or virtual classroom can be transported outside of the educational institution in order to benefit the surrounding communities. There's a literature in rhetoric and composition, my field, called community literacies. We have an entire literature and a body of research in that particular area. I want to ask you to consider the issue of vicarious and contributory liability as you craft the exemption. 1201C2 says that nothing in this section shall enlarge or diminish vicarious or contributory liability for copyright infringement in connection with any technology, et cetera, et cetera. As you craft the exemption, when you think about giving it just to one type of person and not the other type of person that may be working closely, such as student, teachers, community groups, I caution you on setting up a situation where teachers, for example, could be found to be vicariously liable for infringement by students and students by community members. And the Grokster opinion gives us some precedent that that is a possibility. I also want to remind you about Section 1201C1, which states that nothing in this section shall affect rights, remedies, limitations, or defenses to copyright infringement, including fair use, under this title. The other factors that I want to remind you that you need to consider are 1201AC2, the availability of works for nonprofit archival preservation, and educational purposes. It says educational purposes, and it does not say educational institution purposes. So this is, again, connecting back to what I was talking about with work students do with nonprofits and community media centers. Also, you will consider the impact that the prohibition on the circumvention of technological measures applied to copyrighted works has on criticism, comments, news reporting, teaching, scholarship, or research. Teaching is only one factor listed there. There are other factors that are listed which are not necessarily confined to the educational institution. And also, I do agree that we should look to what members of Congress intended, and the DMC, the act of circumventing for measures intended to prevent copying was not intended to be prohibited. This is something that you all discussed in the April 3rd transcript in 2006, but I didn't see any resolution on this particular issue in the final recommendation. The reason given in the legislative summary about differentiating between copying for access circumventing for access versus circumventing for copying is to, quote, assure that the public will have the continued ability to make fair use of copyrighted works. Since copying of a work may be a fair use under appropriate circumstances, Section 1201 does not prohibit the act of circumventing a technological measure that prevents copying, which is what I'm talking about. This is what we're talking about, circumventing to copying. By contrast, since the fair use doctrine is not a defense to the act of gaining unauthorized access to a work, the act of circumventing a technological measure in order to gain access is prohibited. I would be very interested in you revisiting that dialogue that you had in the April 3rd transcript from 2006 and making a determination about the differentiation between circumventing for copying versus circumventing for access. In my research, I also found that digital writing created in educational context travels, and it has a certain kind of permanence. And so my main interest is protecting fair use for writing that travels outside the classroom with respect to work students and teachers do with community groups. I'm going to end by saying that educators do appreciate the availability of digital media via DVDs. We appreciate the quality. At the same time, the quality is what makes the messages contained in that media so very persuasive and compelling. My PhD is in rhetoric and writing. In 400 BC, Aristotle gave us the 5 canons of rhetoric: delivery, arrangement, memory, invention, and style. 3 concepts under the canon of invention: ethos, pathos, and logos. Ethos has to do with the credibility of the author. And I will tell you that a piece of a visual media or a multimodal media or text that is high quality is going to add to the ethos of that author, and that person will have more credibility, and that person that created the high-quality text will be more persuasive. So while we appreciate the availability of digital media as well as the quality, some of us are also terrified about the ability of the motion picture industry to also produce culture, and now in a way that proliferates unimpeded. There's plenty of research and communication studies to show that media influences how we think about ourselves and others. I know that in her recommendation, the Register of Copyrights will look to strike an appropriate balance, but in the scheme of things, the balance right now is too far in favor of the motion picture industry, and currently there is no readily available, effective, and legal means to critique this media in the same basic format, the powerful and persuasive format that this media is presented to us. Thank you.
Thank you. Let's turn to the other side. Bruce, you going first?
Apart from sort of reminding you of what I've said before yesterday and earlier today, my main comment about this is that I think that we're probably in the wrong room. We should be a couple blocks down the street in a congressional hearing room. That basically what this is about is an attack on what 1201 is about. This proposed exemption is extremely broad to the point of not being able to define it. It's not the proponent in the submission said admittedly many of the uses that would be enabled by this exemption are not fair uses, and that what they're trying to do, and the law professor here just said it as well, is trying to develop the jurisprudence of fair use by having this exemption permit activity, some of which would be fair use and some of which may not be fair use. It seems to me that is not what this exemption proceeding is about. if this is something, some of which may not be fair use. It seems to me that is not what this exemption proceeding is about. If this is something that the Congress wants to take another look at, they can certainly do that. But I just don't think this is what this exemption is about, as a fail-safe mechanism, as the Congress described it, for very specific, very articulated fair uses that are not being that are being adversely affected. This is and Congress considered all this, I think, in 1998 and rejected it. There's been legislation introduced fairly regularly in the Congress since then with regard to exemptions to say that 1201 applies, but not where circumvention is for fair use as a broad matter, and the Congress has not enacted that. So I just think that we're in the wrong forum here for most of this discussion. Were you to consider this, nevertheless, I think that it becomes a quagmire of trying to figure out what is permitted and what is not. And again, as the representative of the proprietor of the technology that here, the very concerned that this, on beyond the situation of the other exemption requests, which we're concerned about, as I said, this would very much jeopardize the viability of our technology as a whole. And I just don't think that this is warranted as a result. Yeah, I think that basically is the point I wanted to make. Thank you.
Okay, Steve.
Thank you. Steve Metalitz, again, on behalf of the 9 copyright organizations under the label of joint creators and copyright owners. I'll be very brief as well, because we did discuss this proposed exemption in Palo Alto, and I'll incorporate what I said there. I think, as I said at the beginning of the comments on 11B, the threshold question here is the activity that's being enabled generally or in fact non-infringing? That's the standard that you've been given to apply and that you have sought to apply throughout these proceedings. And I think if there are questions that could be raised about that in 11B, they are much greater questions in 11A because of the breadth issues that Bruce referred to. I know that Ms. Kopus stated categorically we believe that vids are fair use because they're culturally relevant and artistically beautiful. I respect that belief, but I don't think that's a sufficient basis on which to draw the conclusion that the circumvention that would be allowed by this exemption would enable conduct that is generally and in fact non-infringing. In fact, I think it's not really possible to fit this exemption into the standards that you have followed in the past. I think it only becomes, it only gets on the table if you accept the proposal from EFF that accompanied this proposed exemption, to radically change the standards so that anything that might plausibly be considered fair use is covered, and that you can deny an exemption only if no rational court could ever find that the result would be fair use. That's not the standard that Congress asked you to apply. In fact, that is very close to the standard that Congress has consistently rejected, as Bruce indicated. So I would urge you not to take the von Lohmann leap of drastically changing these standards. And I think if you don't do that, if you refrain from that, then I think the proponents cannot meet their burden. Just on the trap for the unwary, I think we went through this in Palo Alto. It's clear that if I understand the trap, no one has ever sprung it. When there are takedown notices under Section 512 on the grounds of claims of infringement, people do have a right under that statute, and I think virtually all the ISPs implement this in some way, for a putback if they feel that it has been taken down for mistake or misidentification. There has been fair use jurisprudence I should say there's been jurisprudence under 512 that talks about the role of fair use in that calculus. And to think that people are refraining from putting it back because they're afraid they might get sued under 1201 when there have been 0 instances of an individual being sued by a copyright owner under 1201A1, my knowledge, and certainly not in this situation. I think the word that Professor Tushnet used to describe this concept that 1201 provides the additional deterrence was nonsensical, and I think the argument about the trap for the unwary also fits that label. I will stop there, but just to say, and again in agreement with Bruce, I think the proponent's quarrel is with the statute. I don't happen to believe the statute is contemptible. I don't believe that it is cruel, and I don't believe that it implicates the 15th or 24th Amendment. But I recognize the views, and I respect the views of the proponents, and they have an avenue for making that argument. It's not within this proceeding. Thank you.
Thank you. Steve, let's start with you. Martine made a point that, if I can paraphrase it, seems to be that you're really here trying to protect the integrity, if you will, of CSS, not as an access control, but as a copy control. In other words, what you're concerned about is that people who circumvent CSS in the context we're talking about here are doing so in order to make copies. Is that a fair characterization of what your concern's all about?
I think all the examples that were given do involve the making of copies, but it's also clear that I think it's been well established in this proceeding and in the courts that CSS is also an access control. It may have copy control features as well, but is an access control.
All right, explain to me why we shouldn't, however, take into account that the ultimate concern here seems to be that it's being used as a copy control, which, of course, we know there's no prohibition on the act of circumventing a copy control. I mean, is the fact that CSS is an access control almost beside the point here when we look at what's really going on?
I don't think it's beside the point, because the job Congress asked you to do was to determine whether the inability to circumvent CSS and other access controls, but in this case I think we're mostly talking about CSS, is impeding the ability to make non-infringing uses in certain circumstances. So that's kind of the assignment that you've been asked to give. I think if you were to ignore the status of CSS as an access control and just say, well, I'm not sure what you would say. I guess you would not grant an exemption, because you would say an access control is not being circumvented, but you would then opine ex cathedra that it's a copy control, and that might have some precedential value, and I suppose could come up in other cases. Certainly anything you say here or any conclusion you reach here would not be relevant in a case brought under any provision other than 1201A1, so it wouldn't be relevant in a 1201B case.
Okay, I think Rob has some follow-up on that.
Just in terms of illustrate that a little bit, and not to point to any particular screen capture, but the issue came up in the context of capture, where I put a DVD into my computer drive, obtained lawful access to a lawful copy of a DVD that I had purchased, rented, whatever, and then was trying to make a copy from the accessible portion that I lawfully obtained. How is 1201A1 being implicated? It's true we have acknowledged that as a general principle, CSS is a form of encryption, and that qualifies as a technological protection measure that protects access. But in the context of how this is being done and the uses that are being made of material that is then accessible, how is that implicated? How is this not a copy control at that point?
Rob, you are bound and determined to get me to express an opinion on how the screen capture technology applies to 1201A1.
I am not. I'm just
and I am
asking
bound
you to
and
answer
determined
that question.
to repeat to you that we are not going to give you that answer today.
That wasn't really. It didn't have anything to do with that, though. If put aside anything to do with that. If I have lawful access and I'm making a copy, is there any access control issue once if I'm making copy of what I'm accessing? Is there an access control issue at that point?
Another way to put it is he circumventing an access control when he's making a copy of that to which he's been granted access?
Well, I think you're getting back to the same question that you posed before, but in fact, once you have, there are statements in the legislative history about the role of the access control ending once you have obtained lawful access, but that was not included in the final legislation that came from the original House version, as I understand. So the answer is, even once you have obtained access, you may have terms and conditions on that access, and circumventing an access control may allow you to do other things that are not consistent with the terms of access.
There aren't any terms and conditions as to the particular user of a DVD. There's no kind of contractual obligations. There may be to the DVD manufacturers or the electronics.
Yeah, but I think actually that's the point of the terms and conditions, or at least which is that the terms and conditions of being able to provide access through the method of decrypting under the CSS license is that there must be mechanisms used in the sort of pathway that the content takes to take it to the point of access as opposed to the point of making a copy of it. And so that is all part of the CSS system. And part of the license requirement with regard to how you use CSS.
But that's only relevant in terms of the licensees, not the users of.
Well, I think the question
copy.
you get to is the question, and again, I'm not in a position to talk about either a particular technology that was referenced, Snagit, or even sort of theoretically at some point how one might conceivably work, but you do get into the question of whether you're avoiding or bypassing and those parts of the statute, which I think would be relevant as well.
Just to follow up on a point, and this sort of relates to how we make a determination or recommendation to the librarian on this particular area, is that, Bruce, you had said that this was something, and I'm slightly going off, but
you don't mention Snagit. Sorry.
Okay. Should be, this is something we should be, or this issue should be over in Congress. Yesterday we were told we should be over the FTC. We're just trying to find where we should be. But isn't it fair to say that at least in context of understanding non-infringing uses and the impact of the prohibition on circumvention, that although Congress didn't create an exemption, they did create a rulemaking. And that's in part the very purpose of why we're here, is to sort of figure out how these technological changes and developments, like in terms of bidding that may not have existed at the time that Congress was approaching this, or some of the new uses that documentary filmmakers have found that they need to be able to use varying new forms of quality of works, that's exactly what we need to sort of understand in the context of fair use and what might be fair use.
But I think the point is the one that Steve made as well, which is that unless you're going to fundamentally rewrite the standard by which you are judging these exemption requests, and at which point and if you do, then I think you've fundamentally rewritten the statute. But unless you're going to fundamentally, then the requesters of this exemption haven't met the standard and can't meet the standard that you previously laid out, and in fact have said that a good some portion of what activity would go on is not going to be fair use, and and that a purpose of this is to develop the jurisprudence of fair use, and I think that is not what this exemption is about. This exemption should be about, or the exemption process is about finding a very particular fair use that has been adversely affected, and then determining whether granting an exemption for that makes sense under the factors of the statute.
But I thought that cuts against the argument that Steve was making, that we should be going back to where we were in terms of what can be exempted. So if a class of works has to be a subcategory of copyrightable authorship without any other references to the use or the users, then we have a very blunt instrument with which to deal with this issue, and any kind of uses would be on the table at that point. So if we were to find a non-infringing use that was substantial and being affected in the course of the rulemaking, then we would bluntly issue that tool, and anybody could, in that class of works, could utilize that.
And well, you would be faced with the question of whether you should grant an exemption in those circumstances. And I think, first of all, you have found, even under the class of work definition, you have found categories of works to be exempted in the previous rulemakings, and in fact in 2006, other than the film professor exemption. And so I think that method of defining class of work has worked in a number of instances, and you've been able to grant exemptions there. I think the question of whether you would be able to grant an exemption for the class of works that is, motion pictures protected by CSS, and the reason why under the previous definition that the determination was no, was that you basically have the point that you're going to undermine the technology as a whole if you grant that, and that's not what the purpose of the exemption is.
But that's not, then I'm missing something still, because if we then do, rather than create the harm that such a broad exemption may entail by opening it up to many other forms of users for circumvention, some of which may be infringing, if we qualify it in terms of particular use or users, and that's something I wanted to clarify in terms of the documentary filmmakers, but I'll come back to that after I put it back to David. If we do qualify it in that way, haven't we? We're not necessarily making new law in terms of saying fair uses of that work, or saying that any documentary filmmaker doing anything will qualify, but it's allowing those uses then within a very narrow subset to be entitled to go forward and at least get to that argument. At least get to the fair use issue, so that it's not the development of new law, it's the allowance of the development of new law.
I think, I'll give you in a second. I mean, I think the film professor exemption is one where, what we've looked at and have come back and said, in the context of the revised approach to class of work, that has the kind of narrow categories, the specific reasons, the demonstration from the proponents. I think the documentary works. I mean, Steve laid out, the joint commenters laid out a number of refinements on the definition, but again, it's a very specific category that can be defined. The concern I have about the exemption we're now talking about is that it is a very broad, undefined, very difficult to define category, where even the proponents admit that some of what will be done here under the guise of that exemption is not fair use.
One last question before, just to clarify in terms of I know David said not to talk about 1201A2 anymore, but I'm going to mention one thing about that. There's been a lot of discussion about how that's not involved, or how any exemption would not apply to that. But at least in the context here, if devices and tools exist out there, which we know they do in terms of DECSS, many, many other forms of decryption software. I am right, am I not, that use of those tools is not a violation of anything?
Could you repeat that question? You're saying the use of a tool that violates 1201, if the tool violates 1201A2, it's not a violation of anything to use it?
Well, I'm saying if there were an exemption, so we're looking at the question of if there is an exemption
okay.
at 1201A1, and the statement is often made, well, you can't do anything to affect section 1201A2. If we create an exemption for 1201A1, then if those tools exist, there is the opportunity for copyright owners, for anyone to go after the makers and manufacturers and traffickers of those tools. But to the extent they exist, they're free for the taking or free for the using by anyone who wants to fulfill that exemption.
I think I would agree that and it wouldn't just be an administrative exemption. It's maybe easier to look at in terms of a statutory exemption, so which exist, which are permanent. And someone uses a tool that is whose manufacture or distribution is illegal under 1201A2. If they use that in order to circumvent in a circumstance in which there's an exception to 1201A1, then that activity of using it to circumvent in that setting is not a violation.
Is lawful.
Yeah, it's not a violation of 1201.
The only point I would make, which is, I agree with Steve, but is that I think you can take into account in determining whether to issue an exemption under 1201A1, whether doing so would actually encourage the development of a 1201A2 tool, which doesn't already exist.
In which case, we'd never issue an exemption unless we know there's a tool already out there.
As I said, you could take it into account.
I think you have taken it.
Okay, we just did. Go ahead. I have
Okay.
any more questions.
Okay, I wasn't ready for that. Let's see. Getting back to the small question I had about, about fixing problems. For Gordon and Jim, that there was some discussion of the requirements for broadcast and the broadcast gatekeepers who will send things back. I just wanted to find out does the issue come up in terms of how do you fix those problems, particularly if the problem would entail, if you were using some kind of lower quality input to that, and the only alternative then was to get a DVD version. How are those problems remedied?
I mean, from my perspective, from the artistic side, generally, the things that are sent back to us, it's not the quality of the image that they're talking about. It is these technical things that Jim is talking about. And usually with time and effort and money, one way or another, we are able to fix that. One of the problems, and I think I mentioned that in my testimony, and it's the same people that these people are referring to, is that sometimes when the quality is degraded, it's really impeding your ability to make the cultural comment that you're trying to make. So does that answer the question?
Yeah, I think
or maybe Jim has the more technical side of it.
Well, I mean, there's always or usually a way to do what we need to do in terms of if we have a low-resolution clip that doesn't meet the screen size or the image size required by public television, we have to magnify it and blow it up, and we get what Tricia was saying about lots of pixelation, lots of bad-looking video, but we have made it a legal size, and it will pass through the public television gatekeepers. I mean, occasionally they will actually say, why are those clips of this historic footage so much worse than the rest of your whole movie? I mean, people see it, and they see it, and we just say, well, that's the only clip that we could legally get, was at that quality and that resolution. So there are ways to fix these things electronically
Without going to the DVD
without
version.
going to the DVD.
Okay.
I mean, we'd much prefer to go to the DVD because then the issue wouldn't even come up because the quality of the DVD is so much better right from the beginning. And I think this issue comes up far more often with stuff that's been put up on the internet because it's been processed and quality lost, and it's copies of copies of copies. It's the wrong frame size. It's got black bars on it. I mean, there's all sorts of problems there. So, we try to get the DVDs, and we use the analog method that I described as our current stopgap. At least we have, if we can get it on a DVD, we can produce an image that's of respectable quality.
And that's also true for compliance with FCC rules?
Yes.
Okay.
Yes. I mean, the FCC rules are what frighten public television, which then say, well, if the FCC wants it this critical, we'll make it even more critical so that there's no issue ever of being, broadcasting material that's not legal, quote unquote. And of course, the internet's the exact opposite. You can put anything up that'll play. There are no rules about frame size and frame rate and pixelization and resolution. It's just whatever.
The SEC rules only insofar as the technical rules, not necessarily the
Yes.
SEC rules.
Yes, exactly.
I'm just looking at the clock. It's 12 minutes after 1. Our afternoon session starts at 2:30. I'd like to set a goal of closing out this session no later than 1:30, although if there's a lot of interest and a lot of questions, we may go past that. We'll see. But we've asked Jim and Gordon a lot of questions. We may have more, and that's fine. But I'd just like to ask people who have questions for the proponents other than Gordon and Jim. I want to make sure that we get those in, too. So let's start with you, Rob. Do you have any?
Let me ask one question in terms of, for bidders and others in terms of, and proponents of that exemption. We started to talk about it yesterday about necessity, and I just wondered if we could get some comments in terms of necessity of use as a basis for requirement. I know that, Rebecca, you addressed this a bit, that there is there some point that we get that where going through a number of different hurdles just actually gets to diminish the ability to make that particular use a reality?
We're already there. I mean, there are two barriers, and they interact. One is the knowledge, because this is a hard distinction to teach, whereas fair use is actually a much easier thing to teach. For example, I mean, if we're fighting about whether screen capture counts, I mean, imagine trying to teach that to someone who is working their way through school and is not, and then even if they happen to have a trust fund on hand, then maybe they could use the way that we're told is the safe way. But that's a big barrier too. I think the question is, if these uses are going to happen, they're going to be made by citizens who have understandings of justice and of fair use, but do not have understandings of copyright law until they get the letter or the takedown. And then they come to us and we say, we would love to help you, but we gotta warn you about this, right? We would be bad lawyers if we did not tell them this is something that could happen. And hearing that, they often say, I'd love to make my fair use case, but you're telling me that I have to go up against this other provision where fair use doesn't matter. So I mean, we're at the point that if we want these uses to continue, that's what we have to have an exemption targeted to that. And let me make clear, we're not attacking 1201. 1201, the statute requires an assessment of adverse effects on non-infringing uses. These are concededly fair uses specific to CSS and specific to non-commercial users. And I got to say, this idea that we've conceded that that the exemption will cover non-fair uses is not consistent with the text of the exemption we've proposed. If there's not a fair use, then there can be a 1201 violation. If we aren't asking for an arguable fair use standard. And to conclude on that, I think the slippery slope we're being asked to fear is that an Article 3 judge will make a fair use determination. From my perspective, that's not even reaching sea level in terms of how far down we are. That's perfectly within the scheme that Congress contemplated, especially since it asked to look at whether there's an impact on non-infringing use.
Can I just very quickly, you spoke to one kind of necessity. In terms of technological necessity, just to iterate that most of this is being made by, as you say, pink-collar workers, but home equipment. One prominent bidder, for instance, I mean, in terms of, I hear some sense that, that people are storing whole converted movies, et cetera. One of the reasons that we do clip, and maybe Tisha can speak to the fact that you can only just take, decrypt little pieces. Most people will actually wipe your hard drive after a vid. You need to work with uncompressed footage to manipulate it, edit it, color it, put special effects on it. When I say that the final product might be a 90 megabyte file, that's the recompressed version. So an individual clip might be several megs in your timeline, right? But then when you're done, you compress down to what is still much bigger than any kind of YouTube stuff. But to work with uncompressed footage on a bidders work on a home laptop. I mean, there's not, it's just your home equipment. And moreover, increasingly computers are packed with iMovie, Windows Movie Maker. There is a kind of invitation to talk back to culture that is being proffered by the machine. And I'm not talking again about complex machines. I'm talking about student machines. I'm talking about the basic machines. And they literally, yes, storage is getting cheaper, and you might have an external drive, but that's a laptop or a desktop with an external drive is still not the setup one would need for some huge storage of uncompressed digital footage. I mean, do you see what I'm saying? It just isn't that setup for our community.
If time permits, I'll come back to a Section 512 question I have, but go ahead.
Okay. Ben?
I have a question.
This is for Rebecca, and this is a point that I think Bruce alluded to earlier involving case law, but what role in this proceeding, in this context, does free speech play?
Thank you. So I think the role that it plays is in making the point that practical barriers should matter to us, that because the non-infringing uses with which Congress was most concerned when considering, putting this procedure in place are uses that have substantial political, cultural, social value. Some of those are educational, and some of those are made by citizens after they leave the school system and are making political or cultural interventions. And yes, those have substantial free speech values encoded in them. And the adverse effect is that without an exemption, these uses sort of get randomly smacked down, and there's nothing that we can do about them because people don't make their free speech with a lawyer in hand. The New York Times, right? When I was in private practice, I reviewed stuff for the Legal Times and so on, right? I would give them an opinion before they published. The people doing remix video now do not have legal staff. So they make their political speech. They think that there's First Amendment value to it. They are right. It turns out they may have made a mistake in how they did it. And so the copyright owner sends a takedown notice. That's the end of it. And I think that has a profoundly distorting effect on even what we get as fair use, because it's great that the New York Times can make fair use. It's great that educational institutions can make fair use and documentarians can make fair use. But that is not the only system of free speech that we have, and part of the wonderful affordances of the internet is that suddenly individual citizens can film stuff and participate and make big changes in the political system. And that's what we're losing. We're losing the uncounseled fair uses.
And this is open, but maybe Steve can answer this. Can we, and this is in terms of the other factors we can consider, can we say if we granted one of these exemptions with regard to DVD, we can use that point to deny another exemption, which is basically similar to that, because otherwise we'd just eliminate the entire system of anti-circumvention using CSS? Am I clear on that?
No.
Okay.
You're not. Could
No,
you try again?
what I'm trying to say is the fact that we would consider one of these classes and grant that exemption, could that be used when we review another class as a reason to deny that, because that would be, you'd be going so much into the way of, well, not defeating the purpose of the whole process of protecting DVDs.
I think if I understand it, I think you're asking whether cumulatively, if you grant a number of exemptions, they could amount to a problem that individually they would not. I think that's true. I think you have to look at the whole context. But I think you also have been asked by Congress to look at this on a case-by-case basis, and in each case ask, is the prohibition restricting or impeding the making of non-infringing uses? And not only do you have to be confident that the use that's being made is non-infringing, and if there's any suggestion here that we are conceding that all of the uses being made that would be covered by this exemption or by the VIDRs are non-infringing, let's correct the record right now. Some certainly are, some certainly aren't. But you have to find that. You also have to find that the reason for, if you find some diminution in the ability to make the non-infringing use, you have to find that it's caused by the prohibition. And you can't base that on speculation, what if, or the view that there's probably a huge beast raging around the countryside here threatening people with lawsuits under Section 1201, and that's preventing people from exercising their rights under Section 512 to put back material that's been taken down. There is no evidence of that. Fred von Lohman was asked that question, and there were no cases. And I think if you ask any of the witnesses today, you will find there are no cases in which copyright owners have sued people or threatened a lawsuit under Section 1201 after a putback.
Chris?
This is a question for the proponents of the 11A class. Yesterday, we talked a lot about narrowing an exemption in terms of the educational use of DVD clip compilations in terms of professors, what kind of professors, what kind of teachers, students, what kind of students. I have a feeling I know the answer to this, but I feel I have to ask it anyway. Is there any way in your proposal that you could suggest a narrower range of permitted users? I mean, you've certainly talked about the type of users you are concerned with, pink-collar people, racial minorities, women. I don't know if that's something you would want to be explicit about in the exemption, though.
I'm not sure the Constitution would allow us to be explicit about that. And this is actually more the point that we shouldn't be picking winners, right? The fundamental premise of copyright protection is that we don't pick who gets to create art in the first place. We actually let it get created, and we treat it equally. Although the other exemptions have much merit to them, what they don't get at is the fact that creativity comes from so many places, and that you only get it often by letting everyone play, which is not to say. And again, I want to go back to this deterrence point. Like this is not an exemption for arguable fair uses. This is only an exemption for actual fair uses, and therefore there can be no adverse effect. It is ridiculous to suppose that people who understand themselves to be making non-fair uses are deterred now, but would not be deterred once we had an exemption in place. That's not how people reason about this. It's also particularly not how they reason about this, given that the commenters concede how widely available this software is. Like, what exactly will change in practice, other than that people who get takedown notices will say, okay, I'm going to send the putback notice now because I am confident that I can make my fair use case.
Anyone want to answer her question? I'll give you a chance in a moment, but I'm more interested in their answers, not to offend you.
I was going to address what Rebecca was saying.
I'm just wondering.
Could you repeat the question?
You want to repeat your question?
How will a change in deterrence work? What will people think in the presence of this exemption that they wouldn't have thought before?
I'm not sure I can answer that question of what will people think. I think the proponents have made the argument that the law is very unclear in this area, 1201, crystal clear in the fair use area. That's easy. That's an easy determination to make, I heard them say, on at least 2 occasions. That doesn't really accord with my experience, and I'm sure, I guess a lot of my clients would be eager to know what it is that makes these fair use determinations so easy. But I think the law on 1201 is clear. It is not random. I think Professor Tushnet made a very good point when she said, if you don't know the law, then the results appear random. And I think that's absolutely right. And certainly there's more that could be done in many areas to make to improve people's understanding of the law. There certainly are things, and without getting into Rob Kasnick's favorite topic, we know there are some ways to make these fair uses that clearly don't involve any 1201 liability, whatever. And we also know that fair use doesn't entitle you to make the copy necessarily in the way you want or in the best quality way, but the purposes of fair use, including the free speech purposes, are fully served in other ways. We've even seen this in the 1201 context. It's been clearly adjudicated in the 1201 context. So there are methods for people to make this speech, and I hope people advising them will advise them about those methods and give them their best advice on what the law is. But this idea that the specter of Section 1201 litigation is somehow impeding the development of fair use jurisprudence. It seems to me that fair use jurisprudence is coming along quite nicely. Thank you very much.
Jim, you had something to say? Do you still?
Well, I was just curious to find out. There's all this talk about these people putting these video compilations together, that they're not aware of some of these free speech and fair use laws. I'm wondering if they're aware at all that using the de-encryption software is also illegal. It's one thing to sort of be ignorant of the uses in terms of copyright, but in terms of the rules against breaking CSS, is that something that...
And the answer is many of these artists no. In fact, they find out when they get the takedown notice. And then we say, okay, we have to assess what method you used to get this. And the answer, quite frankly, is often, well, I don't have a camcorder, right? I don't have a $900 camcorder. I don't have a $1,000 screen on my wall, right? When I started out, I searched on Google to find out how do you make a remix video. And the first result you get, for example, if you search ripping DVDs, is Lifehacker, a huge site, giving you 5 great programs to rip DVDs with. Of course, they thought they were operating in copyright law, right, where they were able to make fair uses. It turns out they're operating essentially in tax law, where, no, you actually needed somebody to guide you through beforehand. The artists who are doing this, who, by the way, are often young, they're certainly not lawyers, find that out way too late. And they don't have the resources to do it any other way. If we want these fair uses, they're going to have to come through these methods because they don't have the camcorders. If the Snagit software improves and if it turns out that it's not circumvention, I will happily engage in the education campaign. I will make that my life's work. But we're not.
He may join you.
Right. In a way, I have. But think like when you're in private practice. If you're at the New York Times, if you're lucky, they come to you before they do the stuff that they know is iffy. But even when we're counseling really savvy big clients, half of the trouble that they get themselves in is stuff that they assumed was okay and didn't need to clear with you, right? And that's for the big companies. That is not how ordinary people go around making art. They don't think of it in that way. And that is the fundamental problem.
Can I, too? One of the sort of fundamental misunderstandings is the distinction people might make is between owning the DVD and not owning the DVD. In other words, there's this understanding that if you like pirated a copy, if you downloaded a copy, like that's not good. But the assumption is that if you bought your DVDs, that is good. And to sort of explain that that's actually not necessarily, that seems to be a sort of ethical sense, like you should pay for your source if you want to vid with it. That's a very common, comprehensible notion that people have. And then when we come and say, well, no, actually, it doesn't matter that you've...
You should have torrented it.
Well, people sort of think, and as I say, I mean, historically, bidders have bought multiple copies that have the best, quality. Often a show or a movie will be released several times. People who've been Star Wars, for instance, are very attached to older, fixed versions of the film, but in fact there is actually in our community a very strong sense of ethics, but it usually has to do with paying artists, which they understand. The idea that something that they own is not then free for this is quite a difficult concept to get across from an educational standpoint.
Okay, it's 1:30. Unless, all right, Bruce.
One very quick point, which is that the purpose of 1201 was to enable the technology to make to allow the content to flow, and not to force people to sue individual users over as some other industries have been forced to do. And I think that if we get to the point where we undermine the technology to the point where it doesn't work for that, and in fact we have exemptions that are broad enough that we wind up developing the jurisprudence on fair use, then we have just really undermined what 1201 was all about.
Can I ask a yes or no question?
A what?
Yes.
A yes or no question? If we have a binding promise from everyone out there that if you answer, it's only going to be yes or no, maybe will be acceptable, but with no explanation.
That took longer than my question. Yeah, Steve or Bruce, I think, Bruce, you mentioned about the CSS was known at the time of the creation of the DMCA and was considered all throughout. Are you aware of any specific mention of CSS in the legislative history?
No.
Okay.
All right. I suspect there will be further questions which will be sent to you folks in writing, but it's been a long morning and we have a long afternoon to look forward to starting an hour from now. So thank you all very much, and we'll see some of you in an hour. Session. Rather than reread the statement we read at the opening of the session this morning, copies have been passed out, so those of you who weren't here to hear it can now read it if you like, just sort of giving a general overview of the ground rules. We have been joined by the Register of Copyrights, who is sitting at the end of the table so as to only infect one of us. We're grateful that she's here, even in her diminished capacity.
Excuse me.
And I guess we have the treat of having only 4 witnesses. Not that the more is not the merrier, but it will make for hopefully an easier afternoon to get through. Our witnesses are, yes, we have Alex Halderman from the University of Michigan, Blake Reed and Harry Surden from the Samuelson Glusko Technology Law and Policy Clinic, and Stephen Metalitz, is it? Yes, from the Joint Commenters. I will read the 2 proposed classes that we will be discussing this afternoon. First, 8A, literary works, sound recordings, and audiovisual works accessible on personal computers and protected by technological protection measures that control access to lawfully obtained works and create or exploit security flaws or vulnerabilities that compromise the security of personal computers when circumvention is accomplished solely for the purpose of good faith testing, investigating, or correcting such security flaws or vulnerabilities. And 8B, video games accessible on personal computers and protected by technological protection measures that control access to lawfully obtained works and create or exploit security flaws or vulnerabilities that compromise the security of personal computers when circumvention is accomplished solely for the purpose of good faith testing, investigating, or correcting such security flaws or vulnerabilities. So we'll hear first from the proponents. Which of you would like to go first?
I'll go first.
Very good.
All right. Well, good afternoon, everyone. I am Alex Halderman. I'm a professor of electrical engineering and computer science at the University of Michigan. I'd like to begin by thanking you all for granting my request in the last rulemaking proceeding. The exemption you granted
covering sound recordings protected by DRM that compromises the security of personal computers has provided valuable protection for security researchers and consumers to test, investigate, and correct these dangerous vulnerabilities. Today, we're here to ask you to expand this exemption to cover other classes of works where DRM presents serious security risks. We respectfully request exemption from the anti-circumvention measures for literary works, sound recordings, and audiovisual works accessible on personal computers and protected by TPMs that create or exploit security flaws. In the alternative, we request that you grant an exemption targeting PC-based video games protected by DRM that compromises the security of personal computers. Each of these exemptions would be limited, as we've said in our request, to cases when circumvention is accomplished solely for the purpose of good faith testing, investigating, or correcting such flaws. The same risks apply in these classes of works we're talking about today, as did in the sound recordings exempted in the last rulemaking proceeding. In the infamous Sony CD rootkit episode, Sony's DRM surreptitiously updated the user's computer to replace security components with ones that would provide more content protection. But these updated components provided weaker protection to the security of the user's PC. They created avenues through which hackers could gain unrestricted access to the computer and the user's personal data. 500,000 users were put at risk in the Sony rootkit incident. Since that time, we have seen other prominent examples where harm was caused by DRM systems that were outside the scope of the sound recordings exemption last time. One case is Macrovision's SafeDisc product, one of the most widely used DRM systems for PC-based video games. It's so widely used that Macrovision contracted with Microsoft to ship a SafeDisc component with nearly every copy of Windows. But in 2007, malicious hackers discovered a flaw in SafeDisc that would allow them to bypass the computer's security systems. This vulnerability affected nearly 1 billion PCs, 2,000 times as many as the Sony rootkit. As bad as these problems were, many security researchers now believe that they're just the tip of the iceberg, merely highlighting security issues that are endemic to DRM products. There's often tension between the strength of DRM software and the security of the user's PC. That is for several reasons. One, DRM systems tend to be very complex, and complexity is the enemy of security. Two, DRM systems tend to adopt risky, often unsupported programming techniques, or like the Sony rootkit, techniques more commonly used by hackers. These are more prone than standard, well-supported programming techniques to cause security faults. And three, DRM systems tend to transfer control of the computer away from the user, putting it in the hands of the content providers or other third parties, for example, through mandatory automatic software update mechanisms. This is an invitation for attackers to subvert these mechanisms and turn them against the owner of the computer. These problems are compounded by the chilling effects of the DMCA's anti-circumvention measures. This chilling effect deters security researchers from investigating problems in DRM software because of the potential threat of lawsuits. As I detailed in my research plan comment, potential DMCA liability might occur in many scenarios that researchers could find themselves in while investigating the security of a DRM product. For example, DRM software is often designed to resist attempts to monitor and understand its behavior using standard software engineering and debugging and forensics techniques. To investigate and understand this behavior, a researcher like me, wanting to investigate the problems, would have to bypass these parts of the protections. Another example is that certain kinds of vulnerabilities that a DRM product might have might only occur in portions of the software that were invoked during an attempted circumvention or after a partial circumvention of the product. So you might say in the nooks and crannies of the program. To test all of these cases, a researcher would need to be able to reproduce those scenarios, circumventing those parts of the system. On the other hand, a malicious hacker, someone who actually wanted to attack a user, would have no qualms about doing this. Hackers are already not law-abiding, and so it's unlikely that they would be deterred from malicious behavior by the threat of a DMCA lawsuit. Finally, in past instances where DRM systems have caused security problems, such as the Sony rootkit, the simplest way for users to defend themselves has been to partially disable or remove portions of the DRM system. In order for users to do this, they need to circumvent part of the system. In order for researchers like me to develop and test such fixes so that we can help users help themselves, we also need to circumvent portions of the system. In my past research about DRM security, as a result of these kinds of necessary behaviors, I often spent more time speaking with my lawyers and discussing the potential legal risks than engaging in actual science. Several of my papers have listed more legal team members than scientist co-authors. That's not the way it should be. Even with the tremendous pro bono legal help of a number of different lawyers, I've had to perform this work at substantial personal risk due to the threat of lawsuits, like the lawsuit threat that I actually received from Suncom after exposing defects in their DRM system. Many researchers cannot make these sorts of personal sacrifices and choose not to study DRM products at all. We find evidence for this in the ongoing controversy over Sony's video game DRM platform called Securom. There have been anecdotal reports from users and others that the product causes security harms and other ill effects for consumers, resulting in a number of class action lawsuits that are pending. For months, this situation has been crying out for an investigation by reputable security researchers in order to rigorously determine the nature of the problems that the system caused and dispel this uncertainty about exactly what's going on. But so far, no such rigorous independent analysis has been published. And I believe the chilling effects of the DMCA are partially to blame. People have other things that they could be spending time researching that are interesting to them, that result in benefits to consumers, but that carry far less cost and personal risk. I have a tenure clock running. I have 7 years to establish a case for why the university should tenure me, and quite frankly, that for most junior faculty members involves trying to do as much meaningful research as possible in that time. If I have to spend twice as much time doing a research project because I have to stop at many points to consult with lawyers, or if I have to risk that most of the way through that project I'll find that I can't finish it because there would be an unacceptable level of risk, then that is a project that perhaps I would not consider repeating. DRM is not going away. On the contrary, it's finding new uses in e-book readers, high-definition Blu-ray discs, online music rental services, and streaming video platforms. It's likely to continue to see widespread adoption as long as it serves to enable new business models. The inherent security risks of DRM and its continued adoption make it inevitable that further security problems will be found in the next 3 years, but the question is who will discover these vulnerabilities first? Will it be researchers who are seeking to protect consumers, or will it be malicious hackers who are trying to find problems in order to exploit them and damage the security of consumers' computers, as happened with the SafeDisk DRM system? Over 40 of the world's most respected security researchers have signed a comment in support of our exemption requests. They state that PC-based DRM technologies have presented serious security risks, that they are likely to continue to present serious security risks in the future, and that they are likely to present inherent security risks. Moreover, these 40 researchers, including people like Ron Rivest, Ed Felton, and Bruce Schneier, state that the potential liability under the DMCA chills security researchers acting in good faith from discovering and fixing such security flaws. Almost all software has security flaws, of course, but they're routinely detected and corrected by independent security researchers. DRM software, by its nature, poses an elevated security risk, so it's unacceptable that the DMCA's chilling effects exempt DRM from the same kind of security scrutiny as is applied to other software. The exemptions we're requesting today would help ensure that that security researchers are able to provide that scrutiny for a variety of DRM products in the coming 3-year period. Thank you.
Thank you. Mr. Reed, you next.
Thank you. Good afternoon. My name is Blake Reed. I'm a law student at the University of Colorado and part of Alex's unfortunately large legal team. Again, I'm here in support of Professor Halderman and proposed exemption 8A, and in the alternative proposed exemption 8B. I'm also here on behalf of the Samuelson Glushko Technology Law and Policy Clinic, and joining me in that regard is CE Law Professor Harry Cerdan, who's sitting to my right, but he won't be offering any remarks. In the interest of getting to the question and answer period, I'll try to keep my remarks relatively brief. Just to add a few things onto what Alex had to say. At the outset, I'd like to thank the Copyright Office for its continued consideration and accommodation of our exemption request throughout the proceeding and at this hearing today. We appreciate your attention to the details of the request. The chilling effect that Alex talked about is underpinned not only by explicit threats of lawsuit and implicit threats otherwise, but by an uncertain legal backdrop surrounding the existing statutory exemptions, in particular the security testing exemption that's enumerated in 1201J. In 2006, the Register stated that it wasn't clear that 1201J applied to the sort of security research behavior that is substantially contained within our proposed exemptions. Indeed, it wasn't clear in 2006, and there have been no developments that make it any clearer today. Now, we're not going to say that 1201J doesn't apply to this behavior. Indeed, we hope it does. If our exemption is not granted and someone like Alex is ever faced with a lawsuit, 1201J is likely to be the first defense to be raised in court. Unfortunately, we're simply uncertain whether it provides the sort of coverage that we would need to successfully defend what would otherwise be a claim of fair use. And in comport with the congressional intent for these proceedings, which is to fill gaps in the statutory exemptions, we think that an exemption would be appropriate, just as the Sony rootkit exemption was appropriate in the last proceeding. There's insufficient guidance for university and House counsel to provide the kind of sign-off for both professional and academic security research projects like the one that Alex has talked about under the cover of 1201J. So as conscientious citizens in the copyright world and the DMCA world, security researchers are likely to ask for that sort of sign-off, and they're not liable to get it. So accordingly, the uncertainty under 1201J forms a serious part of the chilling effect that Alex referenced. And that uncertainty is a sufficient basis, we think, to grant the exemption. There are half a dozen other statutory exemptions enumerated in 1201D through I. I don't think there's any serious contention that any of these apply to all of the behavior contemplated by this exemption. So I won't address any of them specifically unless you have questions about them in the question and answer period. But as a threshold matter, a lot of security research simply doesn't implicate any of these exemptions. And in the limited cases where it might implicate one or another of the exemptions, there's similar types of uncertainty to the type that surround 1201J. So again, I'm happy to get into that on the Q&A, but I don't think there's any contention that they apply. I'll conclude with a brief comment on the joint commentator's proposed limitations to the exemptions if granted. Again, I won't address them all specifically unless they're specific questions. But to put on the record, we strongly oppose all of these limitations as written, as they would, in many cases, completely vitiate the exemptions as we've proposed. We don't believe that they're necessary to curb abuse. We believe that the language in the proposed exemptions as written is going to be sufficient to curb abuse, along with traditional remedies available in contract law and in copyright law. So with that, I will yield the floor and look forward to answering any questions. Thanks.
Okay, Mr. Patelis.
Thank you very much. Good afternoon. It's nice to be back here again on behalf of 9 copyright organizations that are listed in our submission and that are going under the moniker of joint creators and copyright owners. And I want to point out, for the record, it's nice to be back here on May the 7th, 2009. This is 2009. It's not 2003, when Suncom sent a letter to Professor Halderman that he thought was a legal threat. It's not 2006, when this proceeding got deeply involved in the Sony rootkit situation, and there was a great, based on a very thorough investigation that Professors Felton and Halderman had already done about the Sony rootkit and some of the other techniques involved. So we're not in 2006 anymore. We're not in 2003. We're in 2009. We have to focus on now whether the prohibition on circumvention of access controls is substantially impeding non-infringing uses of particular categories, particular classes of copyrighted works. And we have to look at whether it's likely, more likely than not, if that's not occurring now, that it will occur sometime in the next 3 years. So I will try to step through some of those questions as well as to respond to some of the points that have just been made. The questions that we've been going through for the last, now the third day of hearings, is there a non-infringing use that's being impeded? Is that use being impeded? And are there alternative means that don't require circumvention in order to carry out that use? The first question actually is a tougher one than one might think in the case of an exemption that on a subject matter that has already been addressed. If you look at pages 12 through 13 of Professor Halderman's submission, he gives 2 non-infringing uses. One is research. Let me get, if you'll indulge me, I want to get the exact language here. Engaging in good faith computer security research is number 1. Number 2, installing and utilizing the works. So what works are we talking about here? One category the category that was covered in the 2006 exemption, which of course expires on October 28th, and we're now considering these de novo, was sound recordings. I don't think there's any evidence in the record that any access controls are being applied to sound recordings today. Certainly that's a vanishing breed. And so I don't think there's any evidence that that type of work is involved. We have heard, really, if you look at what's in the record, the only examples have to do with video games. And then I suppose the argument is that even if the argument for current interference with non-infringing use has to do with video games, then it may, or rather it likely will in the future, according to the proponents, involve some of these other categories of works. So if we go back to the non-infringing use, engaging in good faith computer security research, I am at a loss to understand how that involves a non-infringing use of a video game. Installing and utilizing the works, assuming we're talking about a video game, I don't think that the DMCA Section 1201A is preventing people from installing and utilizing the video games that they've purchased. So it's very difficult to see what non-infringing use we're talking about here. I think this is why perhaps the office stated in the 2006 decision that it is difficult to fit these issues into the framework of this proceeding. And I agree with that, and I think it's going to be even more difficult this time because the evidence is quite a bit different, quite a bit thinner, quite a bit more tenuous. But in any case, that's why we're having such a problem fitting this into the criteria that we're using to address every other proposed exemption that is coming before this proceeding. That is quite relevant to this issue that Mr. Reed brought up at the end about the statutory exemptions. And I'll come back to that later, but I think that is why this is so difficult, because we have statutory exemptions to deal with these, with this general subject matter, and it's not satisfactory to the proponents, so we're looking at a potential exemption as well. So if we're talking about video games, let's assume that we have some non-infringing use, and I'm not sure again how it would be impeded, but let's look at the evidence that is in front of us. There are two examples given. One is safe disk. The evidence there is that researchers, for whatever reason, apparently did not discover this problem until after some bad guys discovered it, but they were able to very quickly do the research that was needed to generate a fix and have that widely distributed. Professor Halderman paints this episode in apocalyptic terms of the millions of computers that were infected and how much worse this was than the Sony rootkit. I don't want to underscore the obvious. There was no rootkit involved here. And if you look at the way the normal channels adapted to this to identify the problem, develop the fix, and distribute the fix, we give two examples of that in our submission, and that neither of them thought this was a world-ending problem. It was a problem, there's no question, and a fix was important, but the system worked, the research was done, and the security problem was solved. The other example, of course, is Secure ROM. There that we have a lot of sound and fury. What it signifies is another question. I would submit to you there's far less there than meets the eye. There is no concrete evidence of any type of security vulnerability whatsoever. Now, it's interesting, some people, among the numerous bloggers and commenters who have been complaining about Secure ROM and how it's been applied with regard to particular video games, have raised some security concerns. It's quite marginal. I'd say it's a tiny percentage of the concerns, most of which have to do with why can't I install this on more machines or use it in more ways? Why isn't it more flexible? Perfectly legitimate consumer concerns, but not security concerns. But one allegation, of course, was, well, this is another rootkit. And somehow researchers were able to do enough research into Secure ROM to determine that it was not a rootkit and to get that information widely circulated. Again, I believe we cite this in our submission. So with Secure ROM, I would urge you to read very carefully what the submission says and the follow-up submissions. And Professor Halderman is very careful not to make any assertions about any security vulnerabilities about Secure ROM. He simply notes accurately that there are class action lawsuits pending, that a lot of allegations have been made, there's a lot of furor, there's a very toxic atmosphere surrounding it, and then he makes the assertion that the reason that this can't be cleared up is because security researchers are being chilled in their ability to conduct this research. let's look a little bit at that assertion. Again, we're not talking about 6 years ago. We're talking about 2009. And we have Professor Halderman's sincere observation and belief that DMCA must be at least partly to blame for the apparent lack of fully independent research into secure ROM. I think there are a lot of other possible explanations for that. One might be whether anyone has ever asked to conduct this research or ever sought the cooperation of either the developer of the software or of the copyright owners that employ this software. There's no evidence of that in the record, and maybe there is something that's not in the record and will be brought forward today. But I think I think you have some conclusionary, or I should say conclusory allegations here that somehow the DMCA has something to do with it. Clearly, there could be a lot of other factors at work, and Professor Halderman has mentioned some of them today, such as whether this is an attractive topic for security researchers that are seeking tenure, and whether he would have to, someone who would undertake this research would have to consult counsel. I don't think that the necessity to consult counsel is necessarily a non-starter here. It's not something that takes this type of research outside the pale. I think it's probably fair to say that the entire computer security field is becoming a bit more fenced around with law. There's a lot of legislation on this topic, and I'm not an expert on it, but I hardly think that the DRM situation is unique. I think it's also worth giving the same kind of scrutiny to some of the statements about security problems being endemic in DRM, that DRM is suspect because complexity is the enemy of security, because DRM has mandatory automated software update mechanisms, because DRM systems install a number of drivers in someone's system. Every single one of those statements is equally at least true of many other types of software programs. And I know everyone's always complaining about the complexity of new operating systems and trying to come up with simpler systems. I know I've installed software that has plenty of mandatory automated software update mechanisms, and I do hope and trust that they're not doing me any harm. And I've taken, you take steps to try to prevent that. But my point is that all of these characteristics that are attributed to DRM are also true of lots of other types of software. So let's turn to, we've talked about the as best we can about the infringing, the non-infringing activity and whether it's being impeded. Let's talk about alternatives, and in particular, if you look at the research plan that Professor Halderman put forward, I think what you find that's striking there is how little of it actually seems to involve circumvention. It involves monitoring the operation of DRM systems and observing it. I think the first time it talks about circumvention is on page 3, when he says, look, we want to be able to reproduce these behaviors in we want to have a number of instances running. And Secure ROM only allows you, it's part of the DRM, it only allows you to install the game on a certain number of systems. I'm oversimplifying here because there are actually a lot of ways to increase that. But let's just assume that it only allows you to install it on 5 platforms, and you need to run 15 or 150 instances in order to gain enough data to observe what the problems might be. Well, he says the most straightforward technical solution would be to defeat this part of the DRM so that the system would behave as if it had not reached the usage limit. But it is unclear as to whether this would violate the DMCA anti-circumvention provisions, and so they'd have to seek the advice of counsel. Well, with all due respect, if you need to run 15 instances and the DRM only allows you to run 5, you can solve that problem by buying 2 more copies. There's a very easy alternative that's available that doesn't require circumvention. Similarly, a lot of the other points in the research plan involve observing what happens when, for example, fuzzing, you're basically sending some randomized packets, and you're observing what happens, how the system reacts to that. A lot of this, again, does not involve circumvention. Now, I'm not saying that nothing in his research plan would require circumvention. I'm sure he wouldn't have submitted it if that were the case. But I just think it's worth a careful read to see how much of a problem any limitations on circumvention might be in his carrying out this research, and I think that's relevant to this whole question of whether there's a chill in the air. Let me just turn to just mention briefly the question of the statutory exemptions. In 2003, the office said, where a statutory scheme exists for a particular activity, persons must utilize such statutory exemption to accomplish their goals, or provide evidence why the statutory exemption is unavailable to accomplish a non-infringing use, not simply that the user could have accomplished his or her goal more conveniently by deviating from the congressional design. I think that was the right way to approach this and remains the right way to approach this issue of the impact of statutory exemptions. I think that viewed as a whole, if you look at the 2006 record, the office was confronted with what it appeared to it to be a very serious situation. I think that kind of comes through pretty clearly in the recommendation from 2006. And I believe it deviated from this principle, and it basically said, well, you tell us whether the statutory, both sides, tell us what you think the statutory exemption means and whether it applies. And because there wasn't a conclusive answer there, the office said, well, we don't think we're foreclosed from going ahead in this area, so we're going to go ahead and fashion an exemption. I don't think that's consistent with the statute. The burden is on the proponents to show every element that's needed for an exemption. And the very first element is to show that the activity that they want to undertake is a violation of 1201A1. If it's not a violation of 1201A1, then there's obviously no need for an exemption. And if it falls within a statutory exception or exemption, it obviously does not violate 1201A1. So although they haven't really addressed the subject, I think these hearings have, like the hanging in Dr. Johnson's dictionary, has helped concentrate a lot of people's minds, and this is another example of an issue that never was really ventilated during 2 rounds of submissions, but we get here on May the 7th, 2009, and now we're going to hear why Section 1201J doesn't cover this activity, why Professor Halderman can't bring his work within that exemption, and we'll look forward to hearing that and to responding to that after we've had a chance to study it. I would say it's not just 1201J. We cited a couple of other 1201G, I believe, and other provisions that might also be relevant here. But it seems clear to me that the design of this proceeding is that the burden of showing the inapplicability of a statutory exemption and the inability to bring your conduct within it falls squarely on the proponents, and they have not met that up to this point. Finally, on the narrowing issue, we did suggest some narrowing changes, which we'd be glad to go into if this is an area where you decide to recognize an exemption. I think the only, again, based on what's happening in 2006, the evidence in the record and anything going forward, I'm not sure how this could be extended beyond video games. But even if it were, we've made some suggestions which we'd be glad to talk about in terms of ways that this could be brought, we think, more closely into line with the previous type of exemptions that you've recognized. And we'd be glad to go through those. A lot of them are the same types of drafting that we've suggested with regard to other exemptions. Let me just close with this. We've heard today that the Sony rootkit was the tip of the iceberg. And I suggest to you that sometimes what looks like the tip of the iceberg is just an ice floe. And it floats out to sea, it's never seen again. A lot of people in the industry, I think, have taken a lot of lessons from the episode of the Sony rootkit, and that's why I think you see such a sparse record today of any real evidence of security threats arising from DRM or from access controls. Of course, there's no way to guarantee that there are none, but we also know that we have an ecosystem in place, not only about DRM, but about all kinds of software that relies on people in the field to identify and bring to the attention of the developers the flaws that may exist. We talk about this in the safe code example in our submission. That obviously is also applicable in the DRM area. But unless you're persuaded that what lies underneath that chunk of ice from 3 years ago is an iceberg, I think you have to rule against this exemption because the burden of persuasion will not have been met. Thank you, and I'd be glad to answer any questions.
Thanks. Let's first give Alex and Blake an opportunity just to respond to anything they've heard from Steve.
Great, thank you. It seems that Mr. Metalitz may be conceding that 1201J does apply to the behavior here, in which case, great. But I don't think we're here to litigate 1201J. That's a matter for the courts. And just as the last proceeding showed, I don't believe that the office needs to reach a formal conclusion on 1201J in order to grant this exemption. We think that uncertainty, as it constitutes part of the chilling effect on research, which is one of the statutory factors, is sufficient. Just to address briefly the 1201G exception for encryption research, some digital rights management simply may not involve any type of encryption, and for that does, that exception contains a caveat that the research needs to be specifically tailored to advance the state of encryption research. And any kind of encryption research that happens to be tangentially related to security research may be not done with advancing the state of encryption in mind and may not succeed in that regard. And in fact, I think that may be pretty likely. Alex may have a little more to say about that. Finally, there's an assertion that this is not 2003 and this is not 2006. And the question that's brought to mind for me is what has changed to remove that chilling effect since 2003? And I don't think there's anything on the table that suggests that. And just to make this chilling effect clear, I want to read a quote from Suncom CEO Peter Jacobs when he was threatening Alex with a lawsuit in 2003. He said, "This cat and mouse game that hackers and others like to play with owners of digital property is over. No matter what their credentials or rationale, it is wrong to use one's knowledge and the cover of academia to facilitate piracy and theft of digital property." Let me read you another quote that's a little bit more of a recent example from the FTC hearing last month that I know Rob was a part of, from Debbie Rose for the Association of Competitive Technology, who represents the DRM industry. And she said, regarding pursuing this kind of security research, she said, "Hey, go for it. If you get scared by one threat of a lawsuit, well, there are lawsuits all the time. Just try it. The Electronic Frontier Foundation will pay for your defense." So I think that's the when we're talking about the chilling effect, there's that kind of rhetoric floating out there. So I think the suggestion that the threat of lawsuit has faded since 2003, I don't think there's any solid evidence of that. So I'll turn it over to Alex to address some of the other thoughts.
Thank you, Blake. Just a few things. We heard we heard a question of whether this is an iceberg or an ice flow. I think that was the question facing the Titanic. And there's certainly ice in the water. There's certainly chilling going on. I would say that granting these exemptions is certain to alleviate some amount of harm. I believe that it's going to alleviate a great amount of harm. If there is no harm, if there's no evidence of harm in the future, then there will be then I'll be proven wrong. But I don't expect that that's going to be the case, and neither do the signatories of the supporting comment from experts in the security community. A couple of other things. Talking about the I think Steve mentioned the toxic atmosphere and the furor that has come out of the Secure ROM uncertainty. All of these unanswered technical questions about what the software does, what ill effects it's having. These are very interesting questions for researchers about what the Secure ROM software is doing, what harm is it causing, is there evidence that, what evidence does it contain about just the general nature of security in DRM. All of these questions could be resolved quickly if people were able to study it, to study software like Secure ROM without worrying about the threat of a suit. I could task some grad students on it, and we could have answers in a few weeks. Instead of it's been 9 months or something since the controversy erupted. And it's amazing. I have to say that if you want evidence of a chilling effect, I personally have been chilled from making this a top priority for my research group. This is not something that I've tasked people on precisely because I don't want to have to put my students at risk at this time. I think there was one other thing I wanted to address. Actually, I guess I'll reserve the rest of our time.
Okay. Scribbling questions?
A couple. I don't know if they're in any particular organization, but let's try. One of the questions that I think was raised by Steve was, or points made that it isn't clear whether permission has ever been asked for this, and maybe that would be a way of just clearing up all of the chill and uncertainty. Is that the case? Have you had, besides the threat in 2003, which obviously didn't need any further questioning, have there been other interactions and attempts to obtain permission to do what you want to do?
I haven't embarked on a permission request prior to any of the DRM security research that I've done in the past. It's generally not common practice in security research to ask permission because we worry that a regime of requesting permission before would result in a kind of selection bias that software makers who know that there are problems in their software and don't want them to come out would just routinely deny permission to experiment with their software, and software makers that really thought they had covered all their bases would gladly grant it. So it's not the general practice in research to seek permission. I would worry that if the requirement was the same to perform research on DRM systems, that we'd see exactly that kind of effect. That the systems that really had problems under the hood, like the Sony rootkit, their makers would not grant permission readily, whereas software that was behaving well would.
So how do you respond to, at least in terms of, well, maybe you can explain a little just to get to the encryption research exemption which deals specifically with encryption technology and examining scrambling and descrambling information. That particular statutory exemption in 1201G does require that a person made a good faith effort to obtain authorization before the circumvention. And is this something, and I address this to Blake too, to what extent does 1201G resolve or encompass the kind of research that you need to do, or in what ways is it too limited?
I mean, I have to go back to my previous response, and maybe Alex can chime in as well. not all digital rights
communicate them to the public through blog entries to describe what the risks of the system were. We were able to work with Sony to help them develop and test the fixes for the system, and we eventually published an academic paper that described both what was wrong with the system in technical terms and attempted to draw out broader lessons that would help future developers and implementers avoid the same kinds of problems. So talking about the output, it's on a variety of fronts, both within the research community, communicating to the public, and working with vendors. What we would write would depend on what we found, of course, but the interesting things to write, the things that are the details that we need to communicate as scientists are the ones that people need to understand and fix and reproduce the problems involved. So does that answer your question?
I think so. Does it answer your question?
Well, I think if there's some way to come up with an explanation or to distill that into language that could be a further limitation on the exemption, it might be worth considering that. I would stress that on the credentialing issue, if you look at the people that signed the supplementary submission, it's mostly academics, and they're the ones that are asserting that they are chilled anyway. So I think that would be the focus of it. There are obviously a lot of other things you could do in this exemption to make it clearer. We don't even have a definition of security flaws or vulnerabilities, and I think we raised that point last time. There are a lot of things that could be done to make it clearer and narrower, but I would hope that you would conform it to the scope of the evidence and in terms of what actually has been shown about the existence of these, the need to circumvent in order to conduct this research, and the likelihood that some non-infringing use would be impeded in the next 3 years if the exemption is not granted.
Well, and I think that's another good point. How far do we go with that language of security flaws and vulnerabilities? And one thing, sort of specific question I had is in relation to the FTC event a month or so ago, was that there was a statement, I think by the same party mentioned before, having to do with that I think it was software companies or computer gaming companies aren't using DRM anymore, but that there was a new way of basically providing an authentication system, which seems to be at least a different form of protection. To what does those kind of authentication systems fall within this type of situation for security? Vulnerabilities or flaws?
Well, are they DRM? I think they probably fall outside the law's definition.
I think you might be talking about the new Valve service, and I think that was. We can get into the details of that further in a post-hearing question, but I think that service was simply branded as not DRM in some kind of a marketing pitch. But I think subsequent analysis of what that system looked like, it walks like a duck and quacks like a duck, and that I'm pretty sure that was a DRM system that would fall under this. I think that was just some kind of a marketing pitch.
Well, then, is there any way to really define the scope of what we're talking about that would be that would implicate security flaws, or is this really just doing any kind of checking with these categories of works that are protected?
Well, we could try to define security flaws. Of course, there are definitions for these things, and I think a reasonable definition of security flaws would can probably be found in the statute somewhere. Maybe outside of the copyright statutes.
Yeah, I think there might be something in maybe the Computer Fraud and Abuse Act or something like that. But
that might be.
We could look into that after the fact.
I think the important thing is to tailor the definition of security flaws to be wide enough to cover the kinds of problems that we see in other types of software. We're not asking to do any extraordinary kinds of testing that aren't done to discover faults in other programs today. We're just asking to be able to do the same kind of investigation on DRM software without having the risk of a lawsuit.
And the nature of the security flaws may not be revealed until the completion of the research. So we've got kind of an ex post, ex ante problem. If Alex does the research and then suddenly finds that the security flaws that he's discovered fall outside of the definition, then is he subject to liability? So to the extent that there's any limitation on that front, I think it needs to address that situation.
Rob, I would just suggest that this conversation we've been having the last 15 minutes exemplifies why this is the type of issue that Congress addressed in these exemptions, and Congress may yet choose to address it further, but this falls pretty squarely, I think, in the neighborhood anyway of a lot of these statutory exemptions, and I just would reiterate that the office needs to be extremely cautious, follow the path it followed until 2006, and I believe it was, in my view, bumped off that path because of what it felt was very strong and compelling evidence of an immediate problem. We don't have that here, and without that, I think it's time for I would recommend that the office step back, take another look at this, and see where its role ends and that of Congress begins. Where did Congress? How far did Congress want it to go?
There is an immediate problem, and that's why I'm here, because we really do feel a chilling effect within the research community. But if I can point out something that has changed since the DMCA was passed, is that when the DMCA was conceived, we didn't yet have this idea that DRM technologies themselves would pose an elevated security risk. This is an idea that was only really fully formed after we saw what happened with the Sony rootkit. Then security experts started to say, wait a minute, these technologies are doing things that are different from normal application software, and they seem to be presenting unusual levels of risk. So when the DMCA was written, this may not have been a category of security testing that Congress had in mind. So it's not surprising that the existing exemptions at least do not seem to directly match the structure of the kinds of problems that we've seen.
Well, I beg to differ with that. I think you need to look no farther than 1201I to see that Congress was well aware in 1998 that bad things could happen through the use of technological protection measures. In this case, surreptitious collection of personally identifiable information, and so they provided a remedy for it. Yes, I'm sure they didn't anticipate the Sony rootkit, but I think they did anticipate that there could be problems and that there should be a way to fix them, and I don't think that that's at all excluded in the way 1201G, 1201J, and these other exceptions are drafted.
Okay, Steve, my notes tell me, and I have a vague recollection at this point, that toward the end of your opening remarks, you said something that, if my notes are accurate, I didn't follow it, so maybe you can either tell me my notes aren't accurate.
Maybe I didn't either. So.
Well, I was going to say, it may be too long after you said it for you to be able to explain to me what you meant, but let's give it a try. You said there's a disconnect between the exemption and any non-infringing use of a work.
Yes.
Okay, can you elaborate? I wasn't sure I was following what you were saying.
This actually goes back to the beginning of my presentation when I suggested looking at pages 12 to 13 of the submission of the proponents here.
The original proposal.
Yeah, the original proposal, in which, of course, they had to identify what is the the non-infringing use that's involved here. And thank you. So we enumerate in this section 2 non-infringing uses of the proposed classes of works. All right, adversely affected. So one is engaging in good faith computer security research. To simplify this, let's just say we're talking about video games, because that's part of the class of works anyway. So what is the non-infringing use of a video game that is involved in good faith computer security research? To me, there's a disconnect there. And then installing and utilizing the works, clearly people aren't prevented from installing their video games because of the DMCA. So I'm just not sure what the connection. Again, in the analysis we've been walking through on exemption after exemption, we first look at what is the non-infringing use that is allegedly impeded.
Okay, well, let's take it from page 12.
Yes.
13, as you referred to. What's described here, the first thing they describe is engaging in good faith computer security research.
Yes.
So
that is a non-infringing use, but it's a non-infringing use. Is it a non-infringing use of any work that's protected by its access control?
I heard a yes over there. Let's get an explanation.
I mean, I'm at a loss to explain how you could perform security research on a TPM surrounding a work without using the work itself. I mean, unless we're coming up with a particularly narrow definition of the word "use," this seems pretty obvious to me. Alex, you?
Yeah, maybe I would need to install the video game on my computer and run the video game, etc. And aren't these non-infringing uses that are?
Well, that I think maybe to your second point you were talking about. We're talking about the good faith computer security research. So I guess the question Steve is posing is, on a close reading of the statute, is your good faith computer security research, which may in a vacuum be a non-infringing act, is it a non-infringing use of a work or of the work in question, or to be more precise, a non-infringing use of a particular class of works?
Well, we're falling within a particular class.
I mean, yes. So, I mean, we can't very well do computer security research on the product while it's sitting in the box. It needs to be put into the computer. As Alex said, it's going to get installed and used. And I think that's distinct from our second instance of installing and using, where we're talking about users that are chilled because of the security issues on a particular piece of software from using that software. The joint commentators have pointed out in one of their limitations that, in fact, one of the remedies may be to simply delete the software. So that's the sort of installation and use we're talking about in that context. In the security research context, we're talking about installation and use that's necessary to perform the security research. So
your position is you are using that work, you're using the particular computer game when you are performing the security research on the DRM that's attached to it.
Yes.
Okay.
Correct.
All right.
No, well, the question is, are you doing it when you circumvent that access control? You get in the door,
right?
Are you then doing anything inside the house? That's and probably more particularly
inside the house. What do you mean?
Well, you've circumvented the access control. You've gained unauthorized access. Mm-hmm. Now what? So that's the question, and I think the other way to look at it is this the kind of use that Congress had in mind when they said we want the Copyright Office and the Library of Congress to look out to make sure that non-infringing use is being protected? I don't think so.
One reason we have this rulemaking that Congress wasn't quite sure what kind of use it had in mind. That's why it left it to us.
Well, that's true. But usually you would. I just think this is distinguished from a lot of the other things we've talked about because it doesn't really. It seems to me you're breaking the lock, but it doesn't necessarily mean you're doing anything with what lies behind the lock. That's the concern. Maybe that needs to be more clearly defined. As far as installation and use, I think what I just heard is that people are chilled by the DMCA from installing and using the game because there's a prohibition on circumventing the access control. And I just don't think there's any evidence of that.
Okay. So may I respond? In terms of, to get back to the question of how, whether there is non-infringing use involved in the research, I'd like to first refer you to the research plan document that I submitted, which I think details many of the steps that would be involved in actually studying these security questions in a system. But just to give some examples, things that we might need to do to test the system involve, well, let's say we found a problem like the Sony rootkit, and in that case, the fix that one of the fixes that we tested and developed involved removing a component of the DRM system, namely the rootkit itself that was causing the harm. It's like cutting out the tumor in the DRM software. And in order to develop and test this fix, we actually had to remove the rootkit, thereby circumventing a part of the DRM, and then use the system to see to test whether it was then secure. So if using the system after following that circumvention and making, say, running the software, making copies in RAM, all of that is not a use of the work, then I guess I don't really understand.
But, excuse me, wasn't the work in question there the sound recording? Were you playing the sound recording?
I think we needed to test whether the disc was still playable. I mean, what good would the fix be if it then rendered the sound recording totally useless?
Okay, but when you're talking about analyzing the code and so forth, that's the software, the DRM itself, and clearly this proceeding is not about non-infringing use of the DRM.
Well,
it's about non-infringing use of the work that lies behind the access control.
We're talking about testing, investigating, and correcting problems.
And aren't there reproductions and made in the course of that testing?
Things like temporary copies in RAM, yes. Installing the software onto
a use, right?
Pardon me?
That's a use. I mean, and potentially not
potentially
infringing
could be
use
yes.
if it's for a legitimate purpose.
That's right.
Okay.
Okay. I assume you've read the analysis we did 3 years ago when we recommended the exemption that you asked for. Have you read that recently?
Depends on to what extent, but yes,
Okay,
hopefully.
well, you probably read it more recently than I, because I probably haven't read it in the past 3 years. But let's go my recollection, because Steve's characterization, let's assume for the moment that Steve's characterization of what was going through our minds when we made that recommendation is accurate in the following respect. We had evidence of a real problem, a recent problem, that everyone agreed was a big deal, a big problem. We had a situation where we had a statutory exemption that may or may not apply. It wasn't entirely clear. And in the face of all that, we concluded, certainly because Steve wasn't quite as sophisticated in his arguments 3 years ago, I've forgotten about them. We didn't have the benefit of Steve's analysis of what the non-infringing use of a particular class of works was, so we didn't have to deal with that. So we thought, fine, you've got a non-infringing use, we got a real problem, and we got an ambiguous statutory exemption that you may or may not be able to take care of. We got something we really need to worry about here. Let's just deal with it, give you a free pass essentially to fix it, and there we are. 3 years later, we're in a situation where the whole point of this rulemaking, as we understand it, is to take a look at the marketplace every 3 years, see what's going on out there, and deal with what's going on now. It's not our job to legislate. It's not our job to put into place permanent exemptions. It's our job to say what are the problems we are facing now, or that we know with some degree of certainty we're going to be facing in the next 3 years, and let's deal with those. We don't have a record this time, I would suggest, that's anywhere near like the record we had 3 years ago, and I think we're all grateful for that. The rootkit is quite a few years in the past now. So we've got two examples you have, one of which I think is a situation where there are allegations. We don't know whether they're accurate. Another is one where there is apparently a problem, but I have to say, having read the submissions on this particular proposal, I don't have a clue what the facts are. All of the submissions on both sides to be incredibly thin in terms of informing me what the heck it is we're talking about with this, what is it called, secure lock or whatever.
Safe disk.
Safe disk. I don't have a clue. I had a pretty good clue about the rootkit. I mean, I couldn't have technically explained it at all, but 3 years ago, I understood it was a problem. I understood something about the nature of the problem. I understood the harm. No one's given me a whole lot of information as to what the problem is here, the nature of it, the extent of it. And while Steve has told us that the problem was solved, I don't quite understand by whom or how or under what circumstances. So I'm at a sort of a loss on the record in front of us to evaluate the nature of the harm that we are facing right now. And in evaluating the state of affairs today and the likely state of affairs in the next 3 years, I've sort of got to look at what the evidence is in this snapshot we have right now. And the snapshot right now is incredibly blurry to me. So anyone who can help me, I'd be grateful.
Well, I would be happy to talk about Safe Disk in more detail if you would like, but I'd also like to talk about the other example that we are trying to bring to your attention, that is the Secure ROM system, where the facts are blurry, there's a lot of uncertainty, we can't say much to you, and that's precisely because of the problem that we're pointing out, which is the chilling effect that the DMCA is having on security research. So I would posit that the evidence is there, right in the fact that this is blurry, that we have a problem that needs to be addressed.
I mean, I think the other thing to point out is that the rootkit was the first example that you saw, and then you saw Safe Disk, and now we see this blurry situation with Secure ROM. Take that with the assertions that you've had over the past several days that the use of DRM is absolutely necessary to enable a lot of business models, is going to continue extensively. Even we've talked a lot about Hulu. Adobe is poised to add DRM to the Flash player. The use of DRM in the delivery of content is only going to increase. And I think when you look at that with the idea that DRM is going to have some endemic security issues, which those researchers pointed out in the letter, you see a pattern developing. And so not only do you have the issue with Secure ROM right now, you have an extremely high likelihood that it's going to happen again, and it's going to happen a lot in the next 3 years. And I think that's important to address as well.
Well, I guess the pattern I see is I see the rootkit thing, which is 4, 5, 6 years ago, I don't know. And then where does the pattern go after that? Well, we've got Secure ROM, we've got Safe Disk, which, as I said, are pretty blurry. If I'm trying to find a pattern, arguably I need to see a little more than one thing that everyone acknowledges was a disaster several years ago. Hypothetically, we might have had a record today where everyone who came to us would say, gee, nothing's happened since then, at which point I think it would be very hard for anyone to persuade us we need to do anything. What we have now is something somewhere in between that and another disaster. We've got some allegations of problems, one of which is nothing but allegations, and another one of which is people assuring me there's a problem, but not really telling me what the problem was, not giving me any details whatsoever, I think. Now, I grant there are some footnotes, and I didn't follow the footnotes to the source. Maybe that lays it out in great detail. But in what was presented to us, all I picked up from it was, hey, there's a problem out there. And what I picked up from Steve was it got fixed. Okay, but I don't know enough to make any evaluation on either software. I can't evaluate your assertion of the problem. I can't evaluate your assertion it was fixed.
May I give you more information?
Yeah, I'd love it.
Let me tell you some more about the Safe Disk problem. So the Safe Disk DRM system made use of a component that was distributed with Microsoft Windows, and the purpose of this component was to allow Safe Disk to do low-level things with the computer hardware that would not be normally permitted by the operating system security model. To deal with, this was something that the DRM system used in the process of inspecting copies of a game CD to make sure it was original. I believe that was the extent of the purpose of the component. So it was a DRM function that this was executing. But the way it was implemented had a programming defect where it did not check whether a particular input provided to it by the other running software on the system was correct. And as a result of this, a malicious piece of software, if it was installed on the system while with the Safe Disk component, could use it to also bypass the operating system security functions, to execute its own program within what we call the ring zero, or you might hear this called kernel mode in other sources. So it was very much like it was in some ways parallel to the rootkit problem. Someone who already has some access to the computer can use this to bypass the rest of the security system. That was the case with the initial rootkit problems as well. That's why neither of these problems directly allowed remote access to the computer. We later found out that other components of that Sony had used on their CD copy protection did. Specifically, their uninstaller programs opened up a backdoor. But the severity of this problem and the severity of the rootkit on a machine-by-machine basis were comparable. And the safe disk problem affected a much greater number of machines.
And in the real world, as a practical matter, was that problem exploited? And if so, in what respect, and what were the consequences?
I must admit that I don't know whether we have a complete record about how it was exploited. I'm not sure that there has ever been anything published about the extent of it. We may never know. But what we do know is that the bad guys found it first and were using it to attack people, and that's how it was initially discovered by security professionals who later published about it and helped fix it. But we know that the bad guys were using it to attack real users. That was the start.
David, could I tell you what I know about this, which is a lot less than what Professor Halderman knows, but I did read the bulletins that Microsoft issued about this. They stated that it's a driver that's installed with Windows, but it remains inactive until it's invoked by a game. So you have to be running a game, as Professor Halderman said. It's helping to check the authenticity of the game. There was a vulnerability. It was exploited at least once because it came to people's attention. It can't be exploited by a remote user. This, I think, is as I understand it, is a big difference from the rootkit situation. An attacker must convince a user to run an executable or must have valid logon credentials to exploit this vulnerability, according to Microsoft. And, in his submission, Professor Halderman refers to this as a fiasco. I think the evidence is that it was a problem that was not discovered until someone had made malicious use of it. I don't know how extensive the malicious use was, but then it was relatively quickly resolved by an update to the operating system that Microsoft sent out, and that they encouraged people to update at their earliest opportunity. It was apparently, I'm aware of two security firms that were involved with this. That one of the Microsoft and a Danish firm. They have boards where these or they have sites where these vulnerabilities are discussed and patches can be distributed. The Microsoft said it was an important problem. It was it was not their highest severity rating, but it was lower than that. I think they have 4 systems. And I think the Danish firm has a 4 system, and they gave it its second lowest rating, less critical. I'm not in a position to judge whether those are the right evaluation or not, but the people that are experts identified this problem. I think I would not characterize it as a fiasco, and I would certainly think it's quite readily differentiated from the rootkit.
Now, can anyone tell me whether Microsoft and this Danish firm had to violate Section 1201A1 in order to do what they did to fix the problem? Analyze and fix the problem?
Not eventually.
Yeah, I honestly can't say, but potentially.
Well, actually, I mean, you may be the person who's in the best position to help us on this. Yeah. I mean, in order to figure out the problem and to resolve it, would they necessarily have had to circumvent access controls, or would there have been another way to do it?
trying to think of another way to do it. Well, let me get back to you.
Okay, and I don't want to put you on the spot. The fact that you had to think about it for a while may tell us something right away, but okay. Maybe all I've got right now.
May I ask one question?
Yeah.
What is it about, this is limited to just DRM or these particular categories that are on personal computers. What is it about the DRM on personal computers that sets it apart from other security issues?
We have the most evidence that of security problems occurring in DRM software on personal computers. So, for one thing, we tailored it to attempt to fit the facts. Secondly, the security side effects that DRM has are more pronounced or most pronounced when it's implemented in software on personal computers, because that is where these factors that I talked about of complexity, of needing to take on a certain amount of control of the computer, that's where these come into play. If you have DRM that's implemented, say, in a DVD player, then that's not going to implicate the security of your other data because it's separated from your computer. If you have DRM that's implemented, say, in a Blu-ray drive that is used as a computer peripheral, then the software in the drive is, again, in a certain way isolated from the computer. It can implement protections without having to compete with the user for control and administrative understanding of the operation of the computer.
So that in some way goes to the depth of the DRM within the computer and the kernel. And
yes, it goes to this tension that seems to exist between implementing DRM entirely in software and having it be strong, and things like the complexity of the system. That implementers of DRM entirely in software tend to resort to very complex measures. They tend to resort to they tend to have to limit the user's ability to understand what's going on in the system, as the rootkit was directly designed to do this. But those things are not necessary if you're implementing DRM outside of software. So I don't think there is, that we know today, a reason to conclude that there are endemic security risks to DRM implemented in other forms that is not implemented in software. Now, this may change in the future if we have the opportunity to study it, but the problem as I see it now is one that is primarily one of DRM software.
And given that depth and complexity within the operating system, then is that something, it seems like it basically can integrate into that other computer program, the operating system, this goes back to that same question, and if you can't answer this now and can answer that when in getting back to us on it, but to what extent, and this was an issue with the rootkit too, to what extent can the owner of the operating system, like Microsoft in this case, simply create a fix that deletes those particular portions, or to what extent does this involve some kind of use of the actual work itself? So if you can...
So the owner of the operating system, Microsoft, could produce a fix, and they did produce a fix to the SafeDisk component. But I'm not sure about the exact facts in the SafeDisk case about what they would need to test. But in cases like the Sony incident, they certainly needed to test whether the software was still functional after they deleted the rootkit component, and that would necessarily involve circumventing the DRM themselves. And I think it's likely that they would need to do something similar in the SafeDisk case in order to test the whether the fixes they put in place left the games involved in a functioning state, or whether it rendered them unusable. So the circumvention comes up in various points in the research plan, but the thing where even the operating system vendor, if they were just told there was a problem here, they would still have a duty to their customers to test the fix that they were rolling out to make sure that it was functional, to make sure it didn't do more damage than the original bug. And that's a case where, as I talk about in the plan, circumvention may be necessary.
And any questions?
No, I'm good, thank you.
Chris? Well, I think for now that does it. Good chance you'll get some follow-up questions from us once we've absorbed all of this. Thank you very much, and we resume tomorrow morning at 10 again, is that right?
Right.
Okay.
Thank you.
It's like getting out early for recess.
You don't have to come till later.